Yes. Made previous, Your Lordship. Lordship, I beg to mention listing of a bail application which was last listed on 25th, my lord.
If it pertains to my bench, you can.
Yes, it is pertinent to you. I'm deeply obliged.
May it please your lordship. Lordship, I beg to mention item number 37, lordship.
Sir.
Can it be on,
Failure.
lordship, can it be on 31, lordship? My senior is out of station, lordship.
Which
37 CD received, my lord.
you receive may be written list on 31 pen.
Lordship, there is an interim order that may be
Three
got-
models have been extended the next date of list.
oblige your lordship.
May it please your lordship. Lordship, I am praying for listing of a BA, my lord. Earlier rejected by your lordship. Deeply.
May it please your lordship, I beg to mention item number 18. In item number 18, we have filed an additional affidavit, your lordship. May kindly call for the record. Oblige.
May I please your lordship, I beg to mention for AB.
Pertaining to this bench.
Lordship, lordship, punishment below 7 years. Lordship.
May I please your lordships, I beg to mention item number 41, lordship. My senior C has some personal difficulties today. Matter may be adjourned for today.
So I am appearing for the appellant in this case, lordship.
You are for the response?
Yes, lordship.
Yes.
The person is in custody since 9th April 2025, and my prayer is that my application for suspension of sentence may be heard. So if they have some problem today, it may be adjourned today, but a short date may be fixed, lordship.
So we'll accommodate her today.
Yes, lordship.
Fix it, can it be on Monday? On Monday or Tuesday? Tuesday will be better if it's not late for you. The 31st, I'd have half day leave actually. So let it be on 3rd or 4th.
Yes, lordship. 3rd of November.
40 or adjourned for the day. I would suggest you to take it on 4th.
Yes,
For
yes,
better
that
chance.
will be.
Mm.
Yes.
Adjourn for the day. On behalf of the respondent, adjournment, list on 4/11. Okay.
Lord.
4/11.
Obliged.
May I please your lordship, I beg to mention item number 23. I'm for custom department, my lord.
Mhm.
I need some instruction from department actually.
Okay, departmental instruction. Kindly inform the other side also.
I'm appearing with the petitioner, my lord.
Oh, you're for the petition?
Any
So
problem?
when should I fix it?
On 4th of November, my lord.
4th? Is it okay? 23? Adjourn to 4th.
Obliged, my lord.
Oblige.
Adjournment for hearing.
May I plead to
Customs Department.
may I plead to lordship, I beg to mention for listing the 3 regular bail application, lordship.
If it's pertaining to this bench, you
Ye-
can.
Yes, lordship. Another lordship, this is fixed today, but not listed, lordship.
Fix today.
Yes, sir.
Nope.
Deeply obliged.
Please your lordship. It's a POXO matter, lordship. FIR page number 9, lordship. Notice may go, lordship. Call for the case diary,
Yes.
lordship.
Investigation. Call for the case diary of Laluk PS case 188 of 25. Accused was arrested and forwarded on 13/9/25. Issue notice upon the respond number 2/informant to the concerned police station. Please the matter on.
On my lord, 13/11.
Is it
My
okay?
lord, another prayer is, my lord, in the cause list,
Mhm.
the respondent name is not showing, lordship. The only state of Assam is showing. And the direction may be given to registry, lordship. Otherwise, we met party.
Respond-
The state of Assam
Oh,
in the cause list, lord.
In the, it is, the respondent side shall also be indicated in the cause list from next day onwards.
Much of it.
Date we have not fixed. Take the date.
13/11.
That's okay.
Much of it.
483 application, lordship. Lordship, POXO matter, notice may go, yes,
Perfect.
lordship. Also, TCR may be called for, lordship.
Trial is going on.
Yeah, no, lordship, it's a charge sheeted case.
You're Mr. Borwa.
Mr. PK Das, lordship.
That counts. Call for the scanned case record within bracket, case diary, charge sheet, etc. depositions, etc. of special POXO case number 64 of 25. Corresponding to Kokrajhar PS case number 129 of 25. So and so, from the court of the learned special judge POXO Kokrajhar.
Kokrajhar Lordship.
Notice may also be issued to the respondent number 2. The accused is stated to have been arrested on 28/5/25. This is the matter of
On 13/11.
13/11, same.
Oblige.
May, please, your lordship, my lord, POSCO matter, my lord, so probably
Same,
notice,
same.
notice will go, my lord, it's from Dhubri. So case diary, this is not charge sheet.
Okay. Call for the case diary of Support PS case number 58 of 25. In the so-and-so section, the accused is stated to be in custody since 10/10/25. Issue notice upon the respondent number 2. Full stop. List on
13/11.
same date.
13/11.
11. I'm victorious.
May it please lordship, the 483 petition, my lord. Petitioner is behind the bar for 29 days, my lord. Lord,
Accept.
FIR is page 16, my lord. May I read, my lord?
It's 16.
Page 16, my lord.
Yes.
My lord, the one, Anup Tiwari made one accident, my lord, and nearby him, one pistol was also found, my lord. Later one, my lord, one Imdadul Hussain he made and stated that you give your bike to me and I will take your Maruti car to visit one girl marriage, my lord. And a dispute was created there, my lord. That is the main thing, my lord.
Pistol as security.
Madam.
Page
Gets
19
into
is the,
trouble.
page 19 is the forwarding report.
Anyway, so
Yes.
that was the diary, call for the diary.
Yes, CD.
Which
Short date?
support gram. Yes.
Support gram.
You want me to see the forwarding report?
Forwarding is here, my lord.
Yes, no, CD. Here are material
Page
seconds.
18 to 19.
Let us quickly see the case diary.
Yes.
Call for the case diary of support ground PS case number 57 of 25. The accused was arrested on 29/6/25. List the matter on
On my lord, 11/11.
11.
11, my lord. And in the meantime, I may be allowed to correct one date, my lord. 29/6/2005 in place of that 29/9/2025, my lord.
Where?
I may be in para number 3, my lord.
Learned Mr. Baharul Islam, Learned Council, 6 to correct one typographical error which crept in para 3
My lord.
of the bail petition, whereby instead of 29/6,
My lord, it will be 29/9, my lord.
instead of 29/6/25, it should be 29/9/2020. Second to bold correct. The prayer is allowed.
Legal.
You can correct it.
Legal.
My lord, perhaps in this case, my lord, your lordship has perused the case diary twice, my lord. Because, my lord, it is a rejected bail. 3 persons' bail were rejected. And one of them, when he filed the second bail application, your lordship allowed it. Your lordship will remember it is that unfortunate incident when a minor girl fell into the pit. Your lordship may kindly come to page number 72. Page 72. Because the FIR, your lordship, more or less, your lordship has already perused the FIR, my lord. Page 72 is the
72, earlier bail application.
no, my lord, this is the second bail application of the company's director, the main boss who was granted bail. And I take your lordship to page 73, para 6. Page 73, para 6. Para 6, my lord. It is submitted by the learned additional PP that the last endorsement pertaining to investigation is around 10/10/2025. It is revealed from the bail objection that investigation has reached an advanced stage All relevant witnesses have been examined, documentary and electronic evidence collected, and accused person thoroughly interrogated
They stated this.
in the, so my lord, and my lord, the main, he is only an employee of that company, my lord. I can understand, my lord, but probably, my lord, in this case, 53 days, he is, for last 53 days, he is in custody. Further custodial detention for the purpose of investigation in view of the observation at para 6 of page 73 in my respectful submission is redundant perhaps. And my lord, his marriage is scheduled to be held in the first week of December. And my lord, he's just an employee, your lordship, and the main director who was awarded the work, he has been on bail already, my lord, way back on 16/10/2025. In fact, three of them initially filed one bail application. All those were rejected. And on the second attempt, your lordship was pleased to grant bail to the main accused. And then submission was made by the learned public prosecutor that investigation is already at a very advanced stage. So perhaps, my
It
lord,
was also stated by the IO.
yes, my lord, the IO also stated. So perhaps, my lord, in
Maybe,
this case, 53 days is long enough, my lord. At the end of the day, my lord, they do not know the victim. The victim was compensated also.
Anyway, so, this thing, what can be done in this case?
I can produce any short date, my lord, if any.
আপনার অলরেডি দুবার সার্ভিস করে দিলেন নিজে আপনার সাবমিশনে আসে যাতে
তো আমাৰ হেৰি আগৰটো পৰা লৈ লওকচোন কষ্ট এটা কিছুমান থাৰ্ড এম বিশ্বাস লাৰ্ণেড কাউন্সিল ফৰ first paragraph, second, third, page 76 or second, third paragraph, let's say. Earlier bail petition on behalf of the accused, along with two others, were rejected. It is submitted that however subsequently, co-accused, arrested co-accused Avinash Bhatia, who was the director of the particular firm, was granted bail on 16/10/2025 in BA number 3237 of 2025. The Learned Council has drawn my attention to para 6 of the said bail order, which reads as follows. When can you get the case diary?
No, your lordship, any short date as per the convenience of.
my
the
lord, whether case that
Direction, the Learned Council has also drawn my attention to a copy of a wedding invitation and submits that the marriage, the accused is to be solemnized on 2nd December.
But perhaps, my lord, at this stage, your lordship may consider the most.
Call for the case diary, but the accused is in custody since 4/9/2025. Call for the updated case diary. However, in the interim, the accused so-and-so is allowed to go on bail of rupees 30,000, one security of the like amount to the satisfaction of the concerned learned court. And subject to the conditions that he shall continue, he shall cooperate with the remaining investigation. He shall not hamper or tamper with it. Let him go since his marriage is fixed.
Otherwise, I can get an update,
You're gonna get an update.
up-to-date status report along with the
Yeah.
specific.
All for the case diary updated because I wrote that order from the, also I perused the detailed bail objection where the IO had stated all these things. So, in the meantime, call for the case diary along with status report, the investigation. Probably it's completed also in the meantime. It's a list on, and can.
He can get a long date because since interim is there.
No,
Subject.
no, long date also because,
Yes, 7/11.
7/11.
yeah. So if it's allowed, it can be free.
Absolutely, I'm deeply.
In the
marriage
meantime,
is
if
also done.
certificate submitted all.
Maybe.
Maybe.
7/11.
7/11 is it. My lord, similar,
Well, 7/11, I will not be here, but that's, it has to come before me.
yes.
I'll not be here, I'll be in Itana.
Then on my lord, your lordship may fix it on
It
30.
is for 1 week now, but it will be probably another week. 2 weeks.
Then my lord.
They are always sent for 2 weeks usually.
Yes,
14 করে দিও 13 তারিখে তো অলরেডি আপনি কেটামান রয়েছে
Then the interim will be extended.
yes.
Let it be on 7/11 only.
my lord, can it be any day barring 7, can it be on 8, my lord?
Yeah, I have no problem. 8 is holiday.
8
8 is
is
holiday, then next week will
on 10/11.
10/11. My lord, in fact, same order may go for item number 8, barring one line that marriage is fixed. Otherwise, he's also an employee.
Well, that is one of the reasons I considered interim.
Ah.
But the other person,
Other person, my lord, similarly situated, he in fact is more innocent in the sense, my lord, he has a two minor children, my lord, the wife is sick, my lord, he has to take care of, my lord, and 53 days, my lord.
accused, which number, item number?
Item number 8, same. They are employees of the farm.
No. It is submitted that the accused is in custody since 4/9/2025. And he has two minor children. And who are presently keeping unwell and his wife is having to take the entire responsibility.
Present
Which-
petitioner is the deputy project manager of
He's safety officer.
yes.
Interim.
Earlier is the
Interim-
safety.
Interim.
10/11.
I'm DPO.
Which date you took? 10/11.
Yes.
10/11 has been taken. I'm DPO.
Okay. May I please, your lordship, he was arrested on 25/7/2025, and as on today, lordship, 94 days. Lordship. He is a head constable of the CRPF, lordship, and
It's a commercial quantity.
commercial quantity, lordship. He was arrested only on the basis of statement of the co-accused, lordship. And in this case, lordship, there is a statutory violation, lordship, section 48 of the NSS, lordship, that will find page 37, lordship. I have stated in my petition, lordship, in paragraph
47,
lordship,
both the notices violated.
lordship. The grounds of arrest were not communicated to the family members, lordship. They issued 48 notice, but it was not supplied to the family member of the petitioner, lordship.
It was not supplied.
Not supplied, lordship. I have stated in my paragraph 8 of my petition, lordship.
You are appearing for the NCP?
Lordship.
NCP. When can you get it's here only, na, in Guwahati only, Guwahati branch only.
NCP,
Get the
Lord.
case there, isn't it?
Lordship.
I'm of PCI, it appears to be lacking, but anyway,
Lordship.
so it will be, I prefer, given a choice to have a look at the, cross-check it from there. only.
Lordship.
Prima
Shortage-
facie, this content is also inadequate, it seems.
Lordship.
Anyway, you said that it was not supplied also,
Lordship.
but content is also doesn't appear
Lordship.
to be, we will cross-check it. When can you get it? The accused.
3/4 of November,
Mhm.
Lordship.
November
Call
3rd,
for the case diary of, case diary of NCP, you get the original case diary, the investigation case.
Lordship.
Yeah, you call for the scan number, case diary of NCP crime, Guwahati crime number 10/25 under so NDPS Act. The accused was arrested on 25/7/2025. The learned counsel, and just for reference, and just the learned, Mr. Ayush Chaudhary, the learned counsel, contains that firstly, the accused was arrested only on the basis of co-accused statement. So semicolon. Secondly, the 48 notice was not furnished to the family member. And he has stated the same in para
8.
8 of his bail petition. List the matter on
3rd of November.
third.
Obliged, Lordship.
Can you get it? No problem.
UP, Your Honor.
Oh, 7.
May it please your lordship. The petitioner in this case, your lordship, there is an allegation that he was the one who has given bribe to a public servant amounting to rupees 10 lakhs. But in this case, your lordship, may kindly peruse the FIR. Is it? page-
Abatement. Abatement offense, right?
Yes, abatement offense. Your lordship, may kindly peruse page 22. May I read, Your Lordship? Information received from reliable source that Sri Maisram Nityan Kumar Singh, Executive Director, and Regional Officer, National Health, Highways and Infrastructure Development Corporation Limited, Regional Office Guwahati, is indulging in corrupt and illegal practices and in pursuant thereof entered into criminal conspiracy with Sri Binod Kumar Jain and Sri Amit Jain, representative of Messrs Mohan Lal Jain, a company associated with construction of national highways under Dibrugarh Project Management Unit of NHIDCL and unknown others with intention to obtain illegal gratification for favorable grant of extension of time and in issuance of completion certificate in respect of the road construction work executed by Messrs Mohan Lal Jain and thereby causing wrongful gain to themselves and corresponding wrongful loss to NHIDCL. Sources revealed that Messrs Mohan Lal Jain, a partnership firm having its office at 99 E Upendra Chandra Banerjee Road, Fulbagan, Kankurgachi, Kolkata, West Bengal, was awarded with the contract of 4-laning of National Highway 37 between Dimou to end of Moran bypass in the state of Assam on EPC mode, besides other contracts under PMU Dibrugarh, scheduled to be completed in July 2024. However, the firm could not complete the said construction timely and completed recently and thus has applied to grant extension of time and issuance of completion certificate for the said period. Sources further revealed that on 17/9/2025, Sri Binod Kumar Jain informed Sri Maisram Nityan Kumar Singh Guwahati that the firm Messrs Mohan Lal Jain has completed the emergency lending facility contract at Dibrugarh and also submitted a request for grant of extension of time and issuance of completion certificate. Sri Binod Kumar Jain also expressed that they desire to meet Sri Maisram Nityan Kumar Singh for issuance of their EOT and completion certificate. Sri Maisram Nityan Kumar Singh advised Sri Binod Kumar Jain to visit him at Guwahati for the same. Sources further revealed that on 10/10/2025, Sri Binod Kumar Jain conveyed to Sri Umit Kumar Jain that they have to visit the Executive Director of NHIDCL at Guwahati either on 13/10/2025 or on 14/10/2025. Sri Binod Kumar Jain further conveyed that their life was spending with Sri Binayak. Sri Amit Jain asked Sri Binod Kumar Jain to talk with Executive Director of NHIDCL and inform him that their completion certificate file was pending and to further seek an appointment from Executive Director of NHIDCL. Sri Amit Jain further conveyed to Sri Binod Kumar Jain that they have to deliver a total bribe amount of rupees 10 lakhs as demanded by the Executive Director. Later on the same day, Sri Binod Kumar Jain conveyed to Sri Amit Jain that he had received a message from Executive Director of NHIDCL conveying that he was presently at Silchar and would reach Guwahati on Monday, that is 13/10/2025. Sri Binod Kumar Jain further conveyed Sri Amit Jain that he will be sending a message to the Executive Director of NHIDCL conveying that he would reach Guwahati on 14/10/2025. Later on the same day, Sri Binod Kumar Jain again conveyed to Sri Amit Jain that the Executive Director of NHIDCL had agreed to meet him on 14/10/2025. Sources also revealed that there were every likelihood the demanded bribe amount of rupees 10 lakhs will be delivered to by Binod Kumar Jain, representative of firm Messrs Mohan Lal Jain, to Maisram Nityan Kumar Singh, Executive Director NHIDCL on 14/10/2025 at NHIDCL Regional Office Guwahati for favorable issuance of EOT and completion certificate. Hence, in view of the above mentioned facts, circumstances, regular case RC 0172025A0012 is registered under section 61(2) of BNS and under section 7, 8, 9, 10 and 12 of the Prevention of Corruption Act 1988 as amended in 2018 against Sri Maisram Nityan Kumar Singh, Executive Director and Regional Officer, National Highway and Infrastructure Development Corporation Limited, Regional Office Guwahati, Sri Binod Kumar Jain, representative of Messrs Mohan Lal Kolkata, and Sri Amit Jain, representative of Messrs Mohan Lal Jain, Kolkata, and unknown others, and investigation of the case is entrusted to Sri Abhimanyu Kumar, Inspector of Police, CBI, ACB Guwahati. Now, this, Your Lordship, there
Yeah,
is
go ahead.
then the pre-trip memorandum, Your Lordship. What I'm referring to is the post-trip memorandum, which starts from page 31. Now, Your Lordship, may kindly peruse page 32, the last paragraph.
Yes.
The car
left.
Yes, the car left after dropping one of the persons. Sources confirmed that the persons who alighted from the above said car is Binod Kumar Jain, and he was entered in the office of the National Highways and Infrastructure Development Corporation Limited, located at Agni Shanti Business Park, second floor, opposite AGP office, GNB Road, Ambari, Guwahati, for delivery of undue advantage of rupees 10 lakhs through Sri Maisram Nityan Kumar Singh, EDNRO, NHIDCL, Guwahati. At around 11:35 AM on 14/10/2025, the source informed that Sri Binod Kumar Jain has delivered the undue advances amounting to rupees 10 lakhs to Sri Maisram Nityan Kumar Singh, EDNRO, NHIDCL, Guwahati. On receipt of information, all the team members, including the independent witnesses, rushed inside the office of Sri Maisram Nityan Kumar Singh, EDNRO, NHIDCL, Guwahati. On reaching the office at second floor, Now, Your Lordship may kindly note this. On reaching the office of second floor, it was found that the chamber of Sri Moisnam Nitin Kumar Singh ED RO is situated on the right side of the reception. When the CBI team moved towards the chamber of Sri Moisnam Nitin Kumar Singh ED and RO, a middle-aged person who was alighted from the car has been seen coming out of the chamber. He was given introduction, self and independence by Sri Abhimanyu Kumar PI by displaying the ID cards, and on being asked, he introduced himself as Sri Binod Kumar Jain, partners of Sri Pawan Lal Jain, a partnership firm having its registered office at 39E Upendra Chandra Banerjee Road, Fulbagan, Kakugarchi, Kolkata, West Bengal. His identity was ascertained by his Aadhaar card number from his possession. On being challenged that he was thus handed over a bribe month in Moisnam Nitin Kumar Singh ED and RO, he became perplexed and did not utter any word. At this, on the instruction of Sri Abhimanyu Kumar PI, he was apprehended by CBI team in presence of above mentioned independent witnesses. On being again asked about delivery of illegal gratification amounting to rupees 10 lakhs to Moisnam Nitin Kumar Singh ED and RO NHIDCL Guwahati, Sri Binod Kumar Jain confessed the same and begged for pardon and said that the same amount is with Moisnam Nitin Kumar Singh to his chamber. Sri Binod Kumar Jain further told that he has given the bribe amount of rupees 10 lakhs to Moisnam Nitin Kumar Singh ED and RO NHIDCL for issuance of completion certificate and extension of time of his contract work. After that, CBI team members and independent witnesses rushed inside the office chamber of Moisnam Nitin Kumar Singh ED and RO, where he was found present. Now, Your Lordship, I would like to pause for a moment here, Your Lordship. The post-step memorandum makes it evidently clear that this particular person, the accused petitioner, was not caught red-handed. He was in the reception, Your Lordship, when this particular incident happened. Yes, the money of amounting to rupees 10 lakhs has been recovered from the other accused, the co-accused, Your Lordship.
No,
But no money was recovered from my possession. There are other documents, Your Lordship. Nothing has been recovered from my house after the search and seizure by the CBI, Your Lordship.
anyway,
May I please, your lordship?
investigation is going on.
Yeah,
or not?
investigation is going on. These are the list of the material which has been taken from their possession. And these are the mobile
He was
phone
arrested
and
on
electronic.
14/10.
This has to be retrieved and it has to be verified still.
You get the case diary.
Yeah,
Your
we'll
Lordship,
get that.
one-
And we need to give a parawise reply also, your lordship.
You want to file a written objection,
Yes, reply, parawise comment.
otherwise reply.
Parawise.
No, Parrot's reply and then a
Otherwise.
case diary. Thank you. Please.
Your Lordship, one more.
Because these are yet to be retrieved. These electronic gadgets are there. So it has to be retrieved.
Retrieve from the other
It
person.
is under the process.
Any-
It will go to the FSL and thereafter we'll come to know.
My only respectful submission, Your Lordship, is this person, Your Lordship may kindly peruse annexure, page 71, annexure 9. This is issued by the Guwahati Medical College and Hospital, Bhanagor, Guwahati, Your Lordship. From the day of his arrest, he is hospitalized, Your Lordship. And he is suffering from, Your Lordship, in the last column, important IMP is written, Your Lordship, had Your Lordship got that, Your Lordship, important,
71.
last 71 page, important. IMP is written in last, Your Lordship, bottom. Hematomyology with bright and coarse hepatic exotexture, pancreatic stations, pericardial effusion. Now, Your Lordship, the meaning of this has been explained by us in paragraph number 12 of our petition. Your Lordship may kindly peruse paragraph 12 for a moment.
Okay.
That the accused petitioner upon admitted to the GMCA's post-arrest was immediately made to undergo an ultrasonography at the Department of Radiology GMCA's on 19/10/2025. The report dated 19/10/2025 revealed that the accused petitioner presented with hematomegaly with bright and coarse hepatic exotexture, which meant an enlarged liver which could indicate serious liver disease, cancer or congestive heart failure. Secondly, the report revealed pancreatic steatosis, which means a buildup on the fat in the pancreatic tissue. Finally, the report also noted pericardial effusion, which refers to an abnormal buildup or fluid in the sac around the heart called the pericardium. All of these findings, specially taken together with the accused petitioner's previous health history, which is stated in the following paragraph, demonstrate that his health is in a very fragile state, which requires further follow-up treatment from super specialists as well as around-the-clock nursing care, which will not be available in custody in the aforementioned circumstances. It is humbly prayed the view of the fragile and serious health condition as well as the age of the petitioner, this honorable court be pleased to grant the privilege of interim bail. So-
You will be given a medical facility wherever you want to go.
Anyway, no,
Yes.
please point it out. Just any.
But he has come all the way from Calcutta here for this purpose only. At
Please
that
stay
time, he was
Calcutta.
not sick.
Anyway, So heard Tia Deori, learned counsel for the petitioner, M. Kumari, retainer counsel, CBI. Was to, at this stage, call for the case diary of RC 12A 25 GWH rising out of FIR number and so under ACB Guwahati under section so and so of the Prevention of Corruption Act. The accused was arrested on 14/10/2025. So pursuant to a trap proceeding with regard to alleged demand for bribes by co-accused who is executive director of National Highway Infrastructure Corporation. Full stop. It is submitted by the learned CBI counsel that they may like to file a reply. The same may be done so expeditiously. List on, when should I? Another line.
May I?
Learned counsel has
11.
drawn attention to page 71 of the page 71 and para. Which was the para? You were
Para
referring-
12, your lordship,
Para
of my
12
petition.
of the bail petition regarding health condition of the accused.
He will be given appropriate medical. care.
Necessary that.
Necessary medical.
Yes, so when should I fix it? ma'am?
11.
May I pray, your lordship, if you, with due
Earlier
respect, your
you
lordship, considering his health condition, may I pray on 31st, your lordship? If your lordship may kindly. pray.
Possible, your lords.
Because
Considering his health condition, only on his health condition, I'm
So
praying.
he will be provided medical
the
facility.
investigator.
New medical facility will be provided.
Accused UTP is directed to be provided proper medical treatment for his for his health issues, if any. Please the matter, it will be, you take it next week,
Yes, sir.
next
Next
week,
week
which
by-
date you would prefer?
By then, 7/11.
7 or 6? Take it on 6. Is it okay? 6, 6/11.
Much.
Very grateful, your lordship. I'm very grateful.
Welcome. Complete name. Complete name.
May I tell lordship? Lordship, this is for ICP application, lordship, the FIR is page 10, lordship. Married. On 2/8/2025, the complaint has been received from this Purva Kumar Bharma of Soil and so that his vehicle number so and so has
Let us see
transferred.
the FIR.
Yes.
Page-
FIR is page 10.
Okay.
On
Apurva Kumar
2025, a complaint has been received from one, the Arup Kumar Verma of so and so, so and so, that his vehicle number so and so has transferred by someone in the name of Rafiqul Islam, so and so, so and so. But the original owner of Apurva Kumar Verma informed that he had not sold the vehicle to anyone and the vehicle is still in his custody. On examination of official file as well as database record, it has come to know that the vehicle was transferred on 10/2/2020 in the name of Rafiqul Islam, son of so by way of documents forgery. Later on communication with the said Rafiqul Islam over telephone, he confirmed that he had purchased the vehicle from a second-hand showroom situated at Dublin and they had made over the transfer of ownership into his name. Over telephone and official letter so and so, Rafiqul Islam has been asked to appear before the undersigned along with all the documents and the vehicle numbers and so at
Yes,
10:30, yes.
I've gone through.
Lordship. Now, Lordship, the petitioner is not the name accused, Lordship, and he is not any connection in this alleged occurrence,
Oh,
Lordship.
Azizur Rahman.
Yes, Lordship. He is an LIC agent, Lordship, and he knows this, Fiqul Islam, Lordship. When the notice from the DTO office were received by the Rafiqul Islam, then he approached to the petitioner with a request that the petitioner may go on his behalf, and petitioner refused, Lordship. So thereafter, Lordship, some was arrested, and the Siddiq Ahmad, I have seen, Lordship, this Siddiq, Lordship, he is also in interim, Lordship, and one official staff, Lordship, he is also in interim, Lordship. So, my lord, I have stated in paragraph 3, Lordship, how I have connected Lordship this Rafiqul Islam Lordship. I am just, I know him just as an agent Lordship, nothing else.
Your vehicle,
And police Lordship, on one occasion Lordship went to my house Lordship and informed that I may be a FIR Lordship. Lordship is
Adjustment.
yes. I'm ready to.
We have, there's some bail of co-accused, I remember handling.
yes.
And I don't remember what the order was passed.
Here, my lord, from the my lord, contents of the FIR, it seems that vehicle owner is Apurva Kumar. Burman. Vehicle, my lord, that is in the name, is still in his possession, my lord. While that vehicle is still is in his possession. by
Apurva
for-
Burman,
Yes, Apurva Kumar, by forging all these documents, my lord.
it was transferred.
Later on, my lord, during
Without his
inquiry, it is
knowledge.
found that that number, my lord, engine number, chassis number of that vehicle
Does not match.
was also mismatched.
not
So, my
match.
lord, probably that vehicle is a theft vehicle. And this, my lord, accused person tried to, my lord, forging the documents of Apurva Kumar Burman in a theft way by changing the name, inserting the name of Rafiqul Islam. And my lord, prima facie, it seems that that vehicle was a theft vehicle. In that theft vehicle, my lord, they tried to insert the name of Rafiqul.
Who are on interim bail, you said?
Lordship, interim bail is Lordship this Siddiq Lordship. Siddiq, who is the owner of the showroom Lordship.
Showroom.
Showroom Lord, who is in interim Lordship. And another Lordship,
By this court,
Lordship, the coordinate bench Lordship. the learned-
ordinance bench.
Yes,
Well, we have also handled actually.
yes, Lordship.
I
And
also remember handling.
another Lordship, my lord,
Remember.
Subodh Chaudhary, who is the dealing assistant of
He is
DTO.
not named. the
No.
FIR. Prima
I am
facie he is not
ready
named.
to.
That
Lordship.
if he is not named, my lord, that is the difficulty. Why he apprehends, my lord.
There's some relation is there.
Yes.
That's why the apprehension.
On behalf of the other petitioners, he actually appeared before the office of the, my lord.
No. I am not appeal. I have not appealed. Lord.
তো লৈ ল'ব পাৰিব নেকি? আমি লিখি দিওঁ, co-accused আমি লিখি দিওঁ। The allegations to লৈ ল'ব পাৰিব। 482 bail application, heard, mentioned. Bongaigaon PS case number 203 of 25, সেইটোও পাই যাব আপুনি। The allegation in the FIR dated 7/8/2025 is ... It is submitted that petitioner, besides not being named in the FIR, is just an LIC agent and having in the course of his work, he knows the named FIR person, FIR named persons. And since police has sought for him, he's apprehending arrest. Call for the case diary, however, with a view to allowing the petitioner to record his statement, is directed that in the interim, so and so, 20,000 advance. Operate with investigation, appear before the higher for examination. This is the matter on
On, my lord, 1711, my lord.
1711.
Pass of that.
May please your lordship. 482 bail application, your lordships. In this case, present petitioner, your lordships, is being a subcontractor, your lordships. And allegation, your lordships, one of SI, who is being an Mukalma PS, and also he alleged that prohibited drugs are kept in the house of Sahabuddin. But this FIR, if we see 13, FIR registered on your lordships 61 subclause 2/11 BNS reduced section 21 subclause A.
Is Sahabuddin, his name is
Yes.
Sahabuddin.
And yes, Babli, and in this case, your lordships, 61 subclause 2 and 11 BNS, your lordship, that actually has not been attracted in this case, and also he's not illegally selling related to NDPS, your
One is
lordship.
what? Organized crime.
Yes.
Yes,
Organized crime.
No, triple one is organized
Triple
crime.
one is.
organized crime, yes.
Triple two is.
That is
criminal
non-bail.
Criminal conspiracy.
Conspiracy,
Perhaps this
Oh,
section. has
Triple
not
one is
come.
organized crime, non-bailable.
non-bailable.
Otherwise, they've given 21, is it?
Yes.
Small quantity. Oh, so 2.62
Yes.
grams of heroin.
The actual fact, your lordships, the petitioner got some personal enmity with
Just
some.
give me 1-2 minutes, I'll read
Crimi-
the FIR.
Criminal antecedent is also.
Just a
there.
minute, I'll
Yes.
have a look at the FIR. Previous case is also there. Anyway, so in that case, we'll have to call the case directly.
Short date may be given. Your Lordship. Mukalma PS in the district of Nalwar.
Call for the case diary of Mukalmo appeals case number 237 of 25. Please the matter on
6 or 7.
7.
7.
I'll kindly pass over the matter of time being.
May I please, Your Lordship,
12 is the transfer petition.
transfer petition, my lord, filed under section 447 of BNS. My lord, the matter is related to a maintenance case filed under section 144 of BNS. My lord, the respondent number 2 has filed a maintenance case before SDGM Gopur seeking monthly maintenance allowance of ₹10,000. Now, my lord, our case is that I'm a disabled person, suffering from paralysis.
You are a husband, you are a husband,
My husband,
and you want to be transferred to Bokakhat.
Bukakat, my lord.
At this stage, we'll issue a notice.
My lord.
At this stage, we can issue a notice.
My
The
lord.
opposite party.
But instead of further proceeding, otherwise it will be fatal for me to travel such a long distance, my lord.
Transfer petition, criminal stop. The petitioner, petitioner so and so. Heard, your good name, please.
M. Hendik.
Lord Counsel. Full stop. The petitioner is seeking transfer of Emma case number 23 of 25. Filed by his wife / respondent seeking maintenance under 125.
125, now it is 144.
144 BNSS. From the court of the learned judicial magistrate, JMFC Gopur to learned JMFC Bokakhat in the district of Golaghat. So the principal ground contended is that the petitioner is a handicapped person, is a challenged person, and therefore it is difficult for him to travel to the present location. They issue notice upon the respondent. Steps may be taken. On the pair of the petitioner side, further proceedings, and it is continuing, proceeding is continuing.
Continuing, my lord, next date is
MR, next one. The further proceedings and MR case number so and so shall remain state till the next date of listing. When should we fix it? After 3 weeks or something?
Yes, sir.
Eighteen 11.
My lord.
Is it okay?
My lord.
Obviously. Bail fee করলে ভালো হবে। Bail fee perhaps upon admission. We'll finish the bail, I think. Yeah, then we can take up admission.
May it please your lordship. On the last occasion, the court directed the BP to get the instructions whether the informant service report has
Oh.
been awaited or not.
My lord, service report is awaited, my lord. Can we, my lord, wait for some time, my lord? Because, my lord, we in the
Today?
process, my
Need
lord.
some time?
Yes,
Today,
my-
today only?
today only,
After
my
some
lord.
time.
We will try.
We'll take a chance, another,
Yes.
another time this.
My
dates.
lord.
May it please your lordship. Lordship, regular bail application, my lord. FIR is at page 12, my lord.
You have served her copy, no?
Yes, we have served. FIR is at page 12, POCSO 16.
Page 12.
12. Typed copy, my lord. Victim is 17 years, 6 months old, my lord.
Okay.
Now, my lord, the charge sheet has been laid down, my lord, on 15/5/25 under section 6, my lord.
Mhm.
Now, during the course of investigation, my lord, the victim girl refused to undergo medical examination, my lord. Lordship may kindly see page number 38. 38. The report of the Department of Forensic Medicine, my lord.
Yes.
She refused to undergo medical examination. And now, lordship, the alleged occurrence as per the FIR is on 27/4/25, my lord.
Mhm.
And now, lordship, may kindly see we have annexed the 183 BNSS statement, my lord, page number 41. At the extreme bottom, my lord, the contrary picture has come out. Page number 41. At the extreme bottom.
I'm reading the full statement, just.
Yes, my lord. Now, my lord, the, again,
Just a minute.
my lord.
Okay.
And now, my lord, the aspect is that, my lord, the birth certificate, my lord, that has been annexed at page 44. That, my lord, the name of the father is different from the name of the husband of the informant, my lord. The name of the father has been shown as Alok Das. And lordship may kindly see again, page number 17. The mother was the informant and wife of Benu Bhushan Dev, my lord. That contradiction is there, of course, a matter of trial, my lord. But apart from that, my lord, he has been in custody for 184 days, my lord. And charge sheet is laid on 15/5/25. And till then, my lord, trial has not ensued, my lord. On the ground that PO has been transferred or PO is on leave, my lord. Even the copies are also not furnished till date, my lord.
Take the copy anyway. At this stage, what have we received? Charge sheet has, diary has been received.
Yes, that is scan copy of PCR as receipt, Lordship.
160/83 I've already seen.
Yes.
Charge sheet on 15/5/25, Lordship.
Has he stated in our 161 statement? 161 statement is there.
Yes.
Has he stated in that statement that she found out that he was already married?
Yes, Lordship, but
Towards the end, he has stated here, actually. We'll come to amicus also. Anyway, please make your submissions.
Lordship, promised to marry, he has made physical relationship with her, Lordship. And
Judgment also came, my lord. That Rian Kumar has been followed.
Apex court judgment.
Apex court judgment.
We have got the scan copy.
Yes, scan
Scan
copy.
copy is there.
Can you flag mark the notice from there?
Oh, Lordship, I couldn't flag mark Lordship.
Oh, can you
Yeah.
just find it?
They have annexed Lordship.
I have an.
Oh, they're next. Okay.
Vihan Kumar and Darshan has been discussed, my lord. Internal page 6, my lord.
Yeah, I've seen.
Internal page 6, my lord, from below last 3 lines, my lord. Therefore, the law as laid down in Vihan Kumar versus so has been approved and reiterated in the above decisions.
NJ Dr. Land Council. New council. Hearing on behalf of the Learned Standing Council NCB Kyle, on behalf, her name has to be given. 483 bail application. Seeking bail for accused Santosh Kumar. Who's in custody since 4/9/2021.
Yes,
21.
yes.
In connection with NDPS case number 47 of 2022. Under section so and so, which arose out of NCB crime case number 24 of 21. And the case is presently pending before the learned additional session judge number 5, Kamrup M. Guwahati. At the stage of trial.
Yes, Lordship.
And at the stage of trial. Mr. Dr. Learned Counsel submits that he has a limited contention and drawing attention to the notice under 50 CRPC submits that considering the nature of the notice punished in the instant case is seeking bail for the accused on the settled law of the Honorable Supreme Court in the case of Purkastha and Vihan Kumar. In support of his contentions, he submits a more recent decision of the Honorable Apex Court delivered on 14/10/2025. In the case of Ahmed Mansoor and others versus state to neutral citation to 19. Criminal appeal number 4505 of 25. That in which the court has approved the law, approved and reiterate the principles laid down in Vihan Kumar. Supra. It's tough. The notice under 50 is reproduced herein below. We need not cross check. No?
Lordship, I have small submission.
Yes,
Lordship.
please.
So at the time of his arrest, he accepted the arrest memo. Arrest memo was specific to the Lordship, petitioner Lordship. And everything was there in arrest memo.
Where is the arrest memo?
Lordship 24, page number 24 is the arrest memo, Lordship.
Earlier that was sufficient.
And he was arrested in 2021, Lordship.
Yes. Earlier that was held to be sufficient. 21.
24, Lordship.
24, madam.
24.
And I check.
Have a look.
Lordship, on same ground, Lordship, on 16/10/25, Lordship, bail was rejected on same ground, Lordship, by coordinate basis. I'm relying on judgment. Lordship may consider.
On the same ground.
On same ground, Lordship.
Then can I take a different view? Oh, this,
Here, Lordship, he was arrested in 2021. Santosh Jamatia was.
sir is here, no? So
My
I
lord,
think it has to go before the.
my lord, that your lordship can, but one point, my lord, one submission, my lord. Lordship may consider the prolonged incarceration. my lord.
No, that's, that will come later, but on
Yes, sir.
technical grounds, Fukan sir is here. He's, Justice Fukan sir is here.
In that case, Lordship, sir was there, Lordship.
So then it has to go for him. Anyway, this submission should be there. However, it is submitted by the learned counsel appearing for the prosecution that the earlier bail petition was rejected by this court on a coordinate bench of this court on 16/10/25. On similar rejected, taking into account similar grounds contended by the petition. And that apart, as per the practice directions, as the said learned journals is still available in this court. Therefore, the instant bail petition may be placed before the appropriate bench. No, that will be okay.
No,
So-
no,
so-
no, Lordship, I am relying on judgment that may be considered.
Appropriate,
I'm
it is
placing the
different case,
judgment.
madam.
It is different case, Lordship.
Oh, this is a different.
Different case,
Not,
Lordship.
not of the same FR, madam.
Okay, okay. I thought it's the same.
No, no.
No, Lordship.
No, actually, see, if the principle was substantive compliance, then perhaps this would have sufficed, that memorandum of arrest is there.
Mm.
I cannot go into hyper technicality.
Lordship,
And since I have been informed, I know. So
Lordship.
this notice, it was not, which is what actually Darshan is trying to say.
Mm.
Actually, but since, as you know already, that our division bench has also said, and I found another case. I have to locate that Ladakh something, you just find out. In that case, Supreme Court has said, Supreme Court has said that if this apparent conflict between two coordinate benches of the apex court, the earlier
Yes,
judgment in point of time, this is our judgment, our division bench referred to Pranay City. But we should also look at the more recent decision, Ladakh something. I've not had the time to, look up, but this has been said there. The principle, it has come, that I have seen. So, in case of substantive compliance, this would have sufficed, that his contention probably would have been, but that has not been said. The Bihan Kumar and Prokasta still speaks about proper compliance.
And this latest one, my lord?
The thing. In this case, the
I'm just relying this judgment, Lordship.
judges said like that. The prejudice test will take it in a very different direction, Let us see, that law will be settled in the coming days.
In fact, the judgment which I have provided to your lordship, my lord, that
That's okay.
Ahmed Mansoor, my lord,
That's true.
there, my lord, the Darshan's case has been also relied upon.
Approved unqualified manner.
Right.
Unqualified manners. They have not qualified that term. So probably,
So this case covers, my lord, squarely covered by Bihan Kumar.
but I will refer to, the learned prosecution refers to a decision of coordinate bench of this court rendered in the case of Chandra Joy Jamatia versus Union, PA 1660/25. And in the order dated 16/10/25, কিন্তু আগৰটো কাটি দিওঁ, ভুল বুজিছিলো মই। এইটোৱে বুলি ভাবিছো। It is contended that this court applying the prejudice test had rejected the contention regarding non-compliance with the notice under 50 in terms of the Nevertheless, in view of the reiteration in the recent decision of Ahmed Mansoor, I am inclined to hold that the aforesaid nature of the notice, even though it was issued in 2021 itself, would not meet the standards stipulated in Bihan Kumar and Prokasta so as to meet the constitutional mandate of Article 22, subclause 1 of the Constitution of India. Thus, the accused is found to be entitled to bail, and despite the existence of statutory bar as laid down, which is one of the principles laid down in Bihan Kumar. Accordingly, should I give the bail amount little higher?
Madam,
1 lakh.
my lord,
1 lakh with one surety of like amount, the satisfaction of the concerned learned court. Additional number 5, right?
5, madam.
Subject to the following conditions. To trial is in
Trial is
process.
going on, trial.
Will available for remaining trial, not hamper, লিখি দিবা। Evidence shall not indulge in any illegal activity. Can I keep this?
Yes.
Lordship,
Will I compile and try to? Application. This is an emerging law, I'll tell you, but prejudice test is always tough. Prejudice test is always tough. It is always tough. There was a case, remember, that there was a judgment earlier that if the IO and the complainant are same, gone, case is acquitted. Then subsequently, a very big decision came, if I'm not mistaken, in Mukesh, where Honorable Supreme Court said that merely because IO informant and IO are same, it will not automatically lead to
Paragraph 20 of Mukesh,
initiate the
madam. Yes, madam.
trial. It'll, prejudice test. But any kind of prejudice test is challenging because you have to again go and determine. There is also a subjective determination. That is why it's tough. Anyway,
I'm obliged.
Bail petition stands allowed and disposed of.
Thank you, Your Lordship. We have not received the case diary.
Lord, here in this case, Lordship, the individual quantity has been clapped together and made it commercial quantity. On the last occasion, your Lordship have recorded some observation. And
As on today, 153 days, I think, no?
from the petitioner Lordship, 12.249 kg of ganja were recovered. And other two petitioners Lordship, into total Lordship 36 kg.
Then we'll, okay. We'll have to see that carefully then.
Yes,
That's
80,
all.
page 18, your Lordship may kindly turn. Is the quantity what has been recovered, has been mentioned.
Page 18.
18, 1/8. $12.249.
In a ground of arrest,
That's all.
point number 6.
If we can segregate, then we can go beyond commercial quantity.
Yeah,
If it is not possible to segregate, then we'll have to go by the provision given.
provision straight on.
But fairness demands that if we can segregate, it should be segregated.
Well, under similar circumstances, Lordship,
15.7, this is the only material that it was separately, because here in the FIR, it is stated, that
But-
cannabis was seized in 3 packets from them.
Yes, Lordship.
And what was seized from which person? It is not mentioned in the FIR.
my lord, in the page 18, 19 and 20. From 321, Lordship, the quantity has been described. Page 18 is from the petitioner,
3 number, they have distinguished.
page 19 from
Fine.
other accused,
Oh, that's fine.
15 kg something,
Well, madam.
page 20.
This is a good job. So if you can do that, that's great, good job. Anyway, so.
My lord, I am relying
This
to
is the-
judgment of our high.
Yeah, you can give me case law. And what has come, what is the state of the case?
A case diary not received yet, Lordship.
Also not received. So then
Wait for a case diary and.
Case diary
we'll go
is
back.
necessary.
That's right, Lordship.
Case diary will be necessary. You were arrested on
Yeah.
28/5.
28/5. As on today.
60
what-
days over, but long, over.
Yes.
But because of, see, he's in custody. I will let me see the decision.
Also,
You can give me the decision, I'll keep it.
এই দুটা দিয়ে। দুটা দিয়ে না।
No, the case diary, the case diary of Bhanga DRPS case number 68, not yet received. Issue reminder for the same. The Learned Council reiterates his earlier submission that itu paragraph উঠাই দিলো। আছে এটা, এই paragraph। That though it was provision pertaining to commercial quantity, উঠাই দিলাম।
But in Sonju Devi Lordship, your Lordship will find at page 4, paragraph 4. And
That's
it-
true. This is, fair enough.
And in another case, Otul Goel, from paragraph three, lordship, last four lines.
Last,
Paragraph three, last four lines, lordship, following the due procedure, when the petitioner was served, 6 packet of suspected cannabis recovered from the petitioner, kept inside a bag, and its total weight found to be 8.7 kg approximately. Similarly, from other 2 persons, so and so. And were recovered from their possession together, approximately suspected cannabis recovered from the possession of 3 persons. Altogether, lordship 22 kg was there. And finally, lordship para 10 and 11, your lordship will find. 10 and 11. And all these 3 persons from different locations. I have no relation with them. I do not know who were there.
when can you, because if we see only, if we consider it an intermediate quantity case is,
That is-
statutory period is over.
Whether that is 150,
Yeah, long over,
54 days.
long over. But can we see it like that? Or should we see it like that?
So, even a sorted lordship, I what is the case there?
Day after tomorrow?
Day after tomorrow, it is very difficult, lordship.
Several,
It's from Bongaigaon, lordship.
It will be a violation of spirit, but not the face of the law, because on face it is
Lordship.
free only, but that's the law. But these judgments indicate that you would, okay, when can you get it?
411, lordship.
Next Tuesday,
For-
next Tuesday.
Next Tuesday.
long date, lordship, yeah. Earlier several occasions, lordship. And it was 31, lordship.
No, I don't know about this, prosecutor.
We can try, but
We also have to take into account their challenges. Should be
They can-
31 or 3,
lordship, 311.
Three-
311.
11. The learned counsel submits before the court two decisions of this court in bail petitions, being Sanju Devi and Atul Goel, italic solely. List the matter on 311.
311.
Published.
Issue reminder for the case date.
May I please, Justice? In this case, as per the last order, learned public prosecutor is supposed to obtain instruction regarding service
Oh,
upon the respondent number 2, lordship.
We have not received any instruction. Today, we have communicated also, lordship.
Lordship, may I submit, lordship, as we have already, we have taken steps by post, registered post, and there is no report, it has not been returned also. So can lordship, presumption under section 27 of General Clauses Act be taken and amicus can be appointed, lordship?
nowadays AD does not come. Nowadays AD does not come.
Yeah, it does not
You-
come.
People use the postal
Yeah.
tracking.
Yes.
Do you have postal tracking by any chance? You have?
No, it is through High Court registry, so we do not have this receipt, lordship. Otherwise, this is a under trial case.
One-
Victim is also examined.
I understand. One option is to ask the registry to cross-check the postal tracking if available, but that will take its own time.
But
They
we have,
all- they have so many work. Or you can.
today we
take
have
press
communicated
instructions.
also, but they have failed to
Okay.
give any.
Or you can
instruction
take
also.
instructions, or we can presume. Should we presume? Will that be okay?
If the amicus is appointed lordship, they will not be prejudiced in any way. And this is 166 days is in jail, and in the meantime, lordship, stopping the proceeding, further investigation has been ordered. So this is also
Yes, sir.
one aspect of the matter.
Steps taken through registered post. Post sent through registered? post.
Yes, lordship.
We can take the
It-
presumption.
presumption.
In a case like this. Can be. I think
Look.
General Clauses Act is applicable everywhere.
Yes.
So now, sometimes we should invoke that provision.
Yes.
In any case, we are appointing amicus.
Yes.
Take care of the interest. As for the office note, steps were received and issued on 23/10/2025 itself. Stop. However, service report. Well, just a minute. Was that this 1 month is not over, no?
No, Lordship, we took it on, first we moved in 8/9, thereafter. There is a previous order,
No,
previous note, Lordship.
oh, so this is a reiteration. Sorry. Eight, nine, right?
Yes.
One notice is 23/10, that's what.
Yes, 23/10 Lordship, through police, it was
Yeah, issued.
police station. Though it was not directed to us to take steps, we submitted it. Because they were supposed to take instruction on that.
It is submitted by the Land Council that steps were taken on 8/9/2025. Full stop. The period of the office note dated 10/9/2025. As per the latest office note dated 24/10/2025, service report is still awaited. The prosecution had taken instructions, was tried to take instructions, but no such instruction is received. Accepting the prayer of the learned petitioner council for invoking section 27 of the General Clauses Act. Considering the elapse of time since sending on notice by registered post as contended, presumption of service is drawn. And should I appear? Please come. Bonita Choudhury, Land Council. May be appointed as amicus to represent the interest of the informant. Spot number 2, the petitioner shall furnish a copy to the amicus. You can fix it tomorrow or day after tomorrow. Tomorrow or day after tomorrow.
Day after tomorrow.
Day after
Day after tomorrow. This is the macro. Right over, thanks. Please, 30 can.
Much obliged.
Lordship. 24 also, we have received an instruction that service is completed. So the amicus may be appointed. My lord.
Okay. Additional PP submits that instruction has been received regarding service of notice upon the informant /R2. However, none appears, therefore M.R. Brown OTP and Malaysia Karen Brown, Learned Council is appointed as amicus. The petitioner, you serve her a copy. Okay.
Lordship.
Tomorrow or day after we'll take it.
Day after tomorrow.
Day after
The sixth
tomorrow.
and day after tomorrow, I will serve tomorrow, Lordship. Copy will be served tomorrow, Lordship.
Day after tomorrow? Day after tomorrow will be 30.
30, Lordship.
30.
Possible.
Yes. Saza.
May I raise a question? Lordship, CD was called for, but probably
Search
CS
sheet-
submitted, yes.
Yes, Lordship. In this case, search sheet submitted. Lordship.
But in this case, my lord, service also probably completed. I am praying for TCR, my lord.
Is it?
My lord.
Uh,
As on today, 80 days, my lord.
It is submitted, but service is not complete.
Service is completed, yes.
Amicus may be engaged, my
I
lord.
have done.
Service upon informant has been completed. And in the meantime, charge sheet has also been submitted. All for the scanned case record within bracket comprising case diary, charge sheet, medical report, etc. Of Jogi Ghopa PS case number 93 of Philly. Accused is stated to be in custody since, I just write down the date for my convenience. Arrested
8/8/25.
8/8/2025. The amicus is to be appointed in.
My lord, yes.
P.R. Deuri. Tapan Ranjan Deuri.
TCR from the special court, my lord, not Sharmala Ohaipuri, my lord.
Because you serve him a copy, Mr. Deuri, you serve him a copy.
My lord. So TCR has to be called from the, my lord, special court.
Yes. Report all from the concerned learned court, that is the court of the
Special just
Bongaigaon.
North Sharmala Ohaipuri.
Jobe, Obhayapuri.
Not Salmara Ohaipuri.
Obhayapuri is not Salmara. no?
Yes, my
Oh,
lord.
sorry, it is not.
The SDGM.
But Abhayapuri, we have the court in, as part of Bongaigaon.
Bangaigaon.
Ohaipuri is within the Bongaigaon district,
Mhm.
but Ohaipuri is a sub, like sub-district level, like, yes, there is also court, my lord.
Nowadays, we have.
A special court also there, my lord.
From the learned special, just Abhayapuri, that will do.
Ohaipuri, North Shalmara Ohaipuri, my lord.
Not Salmara, Abhayapuri.
Masum.
Oh, take the date, Mr. I also forgot. Take the date. When should it be? Thursday,
10-11 Lordship.
My lord.
10-11.
May I please, Lord? My lord, this bail petition, my lord, basically, my lord, notice, my lord. Notice was not, my lord, served under section 448, my lord. My lord,
NDPS, all commercial quantity.
my lord, no, my lord, it is also not commercial quantity, my lord. Why, my lord, 3 persons, my lord,
Again, same.
yes, my lord, clapped and made it commercial, my lord. So, 48, my lord, section 40 is totally violation, my lord. My lord, I have, my lord, obtained.
You have the case diary?
Yes, case there. There are 298 gram from 3 persons, my lord, from accused number 1.
40, my lord, 48, my lord, notice was served, my lord, through my lord, WT message to the, my lord, Elaka, my lord, police station, my lord. So, my lord, which is not duly served, which is violation of the, my lord, Bihan Kumar, my lord.
10 gram from one, 12 gram from another.
No.
12
No, my
gram.
lord, total,
From accused number 1, 132 gram, from 2, 111 gram,
yeah,
Where is it written?
my lord, kindly see page 17, my lord, Caesar list.
455 gram, from 3, my lord, no.
Caesar list, my lord, 17, my lord. It is from petitioner number 1, my lord. Serial number 1, my lord, total 12 packets so and so, my lord, total 132 gram. With that shop case, my lord.
Yes, sir.
It is total quantity from petitioner number 1. Now petition number 2, my lord, page number 9, yes, my lord, 19, my lord. It is recovered, my lord, 111 gram, my lord. And page number 21, my lord. 55 gram, my lord, recovered, my lord. And my lord, after clubbing, my lord, all total, my lord, 298 gram, my lord. If it is not clubbed, my lord.
Of
then-
heroin,
then
brown
it-
sugar, heroin.
yes.
Yes, ma'am.
Brown
Then
sugar
it-
is a derivative of heroin.
And my lord, from petitioner number 3 is no any, my lord, contraband has been recovered. My lord, he is a handicapped person, my lord. And my lord, on the same issue, my lord,
Where is the notice issue?
my lord,
Please,
I
please.
could not annex the notice, my lord, but I have subsequently, my lord, obtained, my lord.
But 3/7/25 actually, July 27, the IO is expected to comply.
Yes, that was, but for which, my lord, I actually contacted the IO regarding that aspect, my lord.
My lord, WT message on, my lord,
He has no.
this is the process, my lord, to serve the notice under section 48, my lord. And another aspect, my lord, 47 notice, my lord, which is also, my lord, mentioned the language, my lord. Language is English, my lord. But my lord, petitioner number 1 is a illiterate person, and petitioner number 2 somehow, my lord, put her signature, my lord. And petitioner number 3, these are, my lord, not well educated in English, my lord. So, my lord, the notice or the ground sub to the petition, my lord, accused petitioners is not in terms of the Bihan Kumar, my lord.
Again, if your standard is substantive compliance, then explaining a English notice in vernacular to the person will suffice.
Yes.
If this may suffice, if
Mhm.
there's a substantial compliance. But
Yes.
if there has to be strict compliance, then it may not. Like one case we took yesterday.
My lord, on the similar issue, my
Suppose,
lord,
my lord,
on the similar issue, my
in a
lord,
language, my lord, which he understands, my lord. Otherwise, if he has not raised any objection at that point of
Yeah,
time,
that will
the
be
time of the
substantial
product.
compliance.
on the similar issue, my lord, on coordinate bench, my lord, granted bail, my lord, kindly see paragraph, my lord, 17, my lord, referring the judgment of Bihan Kumar, my lord. 17, my lord. On the same issue, my lord, WT messages.
All the petitioners are here.
My lord,
They were arrested on 3/7.
my lord, 3/7.
Length of detention is also there.
My lord, 2 days, my lord, 118 days, my lord.
Investigation is not completed.
Investigation is going on, my lord. On that day, my lord, those accused persons were caught red-handed from the, my lord, train, and my lord, train ticket is available. They were together at that point of time. And from
That is fine.
them, that, my lord. Otherwise, my lord, yes, there are some, my lord, regarding that, I have also confirmed
Mhm.
from the IO regarding that WT message. He stated that, my lord, 48 notice was sent through WT message to the.
But whether it was served or not, that's not clear.
Notice.
Regarding that aspect, my lord.
Not clear. Anyway. I'll go through all this, please. Yeah, Mr.
A. Hussein, my lord.
A. Hussain, Learned Counsel, and P. Bhattakur, additional PP. The four petitioners here, accused petitioners herein, namely so and so, invoking 483 BNSS, are seeking regular bail in connection with Guwahati GRPS number 101 of 25 under section 21C 29, the NDPS Act. They were arrested on 3/7/2025, presently in judicial custody. We'll stop. The gist of the allegations in the FIR is about the government railway police GRT personnel pursuant to checking in Vivek Express at the Guwahati railway station, recovered suspected heroin, brown sugar from the petitioners who were traveling, who were passengers in the train. And full stop. Though the aggregate quantity of the suspected heroin is stated to be, kindly help me with this.
My lord,
Stated to be,
Commercial.
my lord, commercial quantity,
No,
but
no.
it is.
What is the amount given?
Amount, my lord, total,
132 gram. No,
132 gram from petitioner number 1.
total has not,
Total
Total, my lord, 298 gram.
298 grams,
Yes, my lord.
thereby falling in the bracket of commercial quantity. And accordingly, such penal provisions have been given. However, the materials indicate that individual recoveries have been, have also been segregated by the police officials. And they indicate recovery of suspected heroin of 132 grams from petitioner
From
number
petitioner number
1,
1, yes.
semicolon.
111 gram from
100
petitioner number,
Yeah, 111 grams from
petitioner number 2.
petitioner number 2,
And
semicolon.
100, only 55 gram from petitioner number 4.
Petitioner number
4.
3
3 is a handicapped person from whom nothing has been recovered, my lord.
from petitioner number 4. It is contended that there is no recovery from
Petition number 3.
petitioner number 3, who is also a challenged person. Though the aggregate of the contraband, suspected contraband falls in the bracket of commercial quantity. But as individual recoveries have been segregated and these amounts fall in the bracket of intermediate quantities each. Therefore, as per the governing principles on the subject matter, the same has to be taken as intermediate quantity for the purpose of adjudication of bail petitions like the instant one, and applicability of the rigors of section 37 of the NDPS Act. The case diary as called for has been received. The learned additional PP submits that the petitioners were traveling together and they were, and their pickets were found, and prima facie they were caught with the suspected contraband. So, full stop. However, the learned additional PP fairly submits that he does not dispute the segregated nature of the individual recoveries. The learned Mr. Hussain, learned counsel also contains about the non-compliance with the notice requirements under section 47, 48. Yeah, 47 has been done.
My lord, 47, my lord, given, my lord, but the
48
language
system.
is.
It is contended that while the section notice under 47 contains the grounds, the same is in English language. And there is no
Which is not-
endorsement as well about translation.
Yes.
This also contended that the notice under 48 is by way of a WTMSS. And
To the
was
officer
not-
of Lahori Ghat
there is
PS.
no material to indicate that it was conveyed to the relatives. From the, this is, you could not confirm it also, right?
Yes.
Could not be confirmed. It should be also fairly submits that whether the notice was delivered to the family member also could not be confirmed from the case there. In any case, the said notices are also in English language without corresponding vernacular component in the language understood by the petitioner. Therefore, the said notice, especially the notice under 48 BNSS would fall short of the standards required under the law laid down in Prakasto and Bihanti. Also keeping in mind the individual quantities allegedly recovered, the statutory period applicable to commercial quantity would not be applicable to the individual petitioners who are in custody since 3/7. Accordingly, in the entire facts and circumstances, I deem it fit to grant bail at this stage according. Thus, allowed to go on bail of rupees little higher, 75,000.
Much.
75,000 each. The surety of the like amount each to the satisfaction of the concerned learned court. This, which court will be additional?
My lord, CGM, my lord,
CGM Kamrup Metro.
Kamrup Metro.
And subject to the condition, CGM or special judge?
My lord, forwarding report says, my lord, CCM.
Concerned learned court. Usually in NDPS matters come directly nowadays. Maybe session judge, any concerned learned court will keep it safe.
My lord, Elaka Magistrate, it will be the.
And subject to the condition, he get a DDB. They shall not have, they shall be available for trial if one commences, not hampered or temporary. They shall not in any manner indulge in any activities violative of the NDPS Act. Stands allowed and disclosed. Therefore, terms. I want.
My lord, special just, my lord, Kamrup, my lord, obvious.
I'll keep this, huh?
Yes,
5 minutes.
obvious, my lord.
It is with me, my lord. Just I am also, my lord, looking for that, my lord.
It's not that, I mean, it won't be sufficient, but it's not that he has not given anything.
Yes, my lord.
But details matter, is much,
Sufficient. if
nothing,
there is a bit
yes.
more Slightly vague, notorious drugs peddler.
Simple, that is,
Not
that is,
cooperate if not arrested.
that to say about the case matter, what is the fact? Why you have been arrested? Only because, and he was arrested subsequently here, man. They have gone to my house, allegation that they found something, and subsequently I arrested after a few days, man. And 146 days today.
Commercial quantity.
Yes, commercial content. That was required in his absence from his house. That is the allegation.
You want to make some submission? Can't.
My lord, actually, I am not able to go through the entire TCR, my lord. Whether, my lord, may it be fixed, my lord, today itself, my lord, after some time, my lord. As because, my lord, only the commercial quantity, that,
Yes,
my
my
lord, for that reason, my lord.
No problem.
My lord, my lord.
You take your time, Moish.
Yeah, two going with.
Oh, that took away, look, sir.
At two.
My lord, then, may it be at two, my lord.
2 hours, no
Just-
matter.
Oh, my lord, my lord.
I have also another matter fixed at around 2 years, your worship.
My lord. Can be-
Obliged. ঠিক আছে চাইলো তুমি
May I please your lord? My lord, here petitioner is behind the bar since 225 days, lordship, 225 days, lordship. Lordship, instruction was sought, lordship, from last day regarding service of notice of conduct.
Scan copy also, my lord, not yet received. no?
My lord, 19 years old boy, lordship. And also there are some violation, lordship, in section 47, lordship, as well as 36, lordship.
Victim has been examined,
Victim already examined, 4 witnesses examined, lordship,
including the victim.
including.
Victim PW3.
What is left? This notice?
Notice.
Oh.
And on last occasion also, lordship, the
Yes, sir.
instruction was sought, lord.
Thank you.
This note is there.
Yeah, lordship, will fix it day after tomorrow.
No, notice has also been sent on 14/10, I think, no, recently.
Yes.
So 1 month is also not. You will have to take the instructions.
Yes.
The scan TCR is available, however,
Scan TCR not received, my lord.
no, it is here.
Causally is, my lord,
It is
not-
here. No, it's not indicated. But instructions regarding service could not be obtained as on today. The prosecution shall take the instructions, list the matter on
on my lord, 30/10, my lord.
30,
On
30/10,
30/10.
30/10.
Online.
May I please your lordship? My lord, 483 application, my lord. FIR at page 10, my lord.
This is also same, my lord. Scan copy of PCR not received and
Charge sheet is submitted.
Suspected matter, my lord. Charge sheet has been submitted during the pendency of this bail application, my lord. Lord, FIR at page 9, my lord, relevant portion, my lord. The allegation is that, my lord, I am a teacher, my lord, and during lesson, my lord, I touched one student, my lord, in the class. my lord.
Improperly.
My lord, this
13
is the
years.
allegation. In the full class, my lord, more than 40 students are there.
And lordship, petitioner is behind the bar since 32 days, lordship, as on date 33 days, lordship. Lordship will find the FIR, Lordship, on page
Yes,
12
I've,
document.
gone through. Actually,
Serious offense, my lord.
these are, no, that's why new offense has been made.
Yes,
actually.
caught red-handed by the public, my lord. And other.
MRPC allegations, if they are true, luckily
Yes.
there were people around,
Yes.
so it could be afraid. Anyway, CD has been
The
received.
CD received, my lord, other co-accused, my lord, who not yet arrested, my lord, that amount is also not yet recovered, my lord.
Lordship, nothing
And
is
these
recorded.
accused persons are, my lord, suspected to be a, my lord, member of, my lord, Irani gang.
Gang.
Yes, my lord. He is from West Bengal, my lord. Bengal.
Irani gang. What's this? Anyway, I'll have a look.
Lordship,
Let me have a look. CD.
Yes.
Snatching is punishable up to 3 years.
yes, Lordship.
It will be 60 days.
Lordship, the investigating officer has got sufficient time, Lordship, for my custodial interrogation also.
What did you find in the regarding that gang aspect?
Yes, my lord, that is, I will point out, my lord. That is in the forwarding report itself, my lord. One paragraph, habitually, my lord, involved in committing this type of offences.
Yes,
Begin-
in the forwarding, Lordship, on grounds of arrest, point number 3, it is mentioned, but that is only mentioned, Lordship. There is no any previous case mentioned in the forwarding, Lordship, reflecting the said fact, Lordship.
During investigation, it is found that the arrested accused
And
person
Lordship,
belongs to.
furthermore, Lordship, the petitioner has undergone 3 days of police custody also, Lordship, so thoroughly interrogated by the investigating agency, Lordship. After 3 days of police custody, he remanded to judicial custody, Lordship, on 29/9.
A person, my lord, which is from West Bengal, my lord, Siliguri.
Lordship, under stringent
He
condition,
came
Lordship.
here.
Missing. First, the petitioner invoking 483 bail application seeking to seeking bail in connection with Mongoldoy PS case number 188 of 25 under section so and so. He was arrested on the day of the alleged incident on 26/9/2025. The allegation, no, he was arrested on 26/9, it no, day of the incident, he was arrested on 26/9/2025. The affair dated 25/9/25, lodged by the alleged victim, alleges that while she was withdrawing, after she had withdrawn rupees 50,000 from SBI Mongoldoy and about to ride her two-wheeler, the accused tried to snatch her money back. And upon her raising hue and cry, he was caught and another fled away. Full stop. The learned petitioner counsel submits that the petitioner was also custodially examined for 3 days during investigation. And considering the length of detention, 6 is bail at this stage. The case diary has been received. The learned additional PP submits that investigation has found material supporting the allegations. In the forwarding report, the accused has been stated to be belonging to West Bengal and being part of the so-called Irani gang involved in habitual snatching. The eyewitnesses have supported the allegation of snatching, and such witnesses have also stated about another co-accused, another co-accused running away with the bag of money, which has not yet been recovered. It appears, has not yet been recovered. The police is trying to apprehend other members of the so-called gang. At this stage, I deem it fit not to grant bail, and accordingly, the bail petition stands rejected at this stage. Return the case there. The investigation be completed.
May please, Your Lordship. My lord, so far notice upon the respondent number 2, my lord, informant is concerned, my lord, my friend is saying. This bail application was filed in the month of July, my lord. Only because of the notice could not be
No,
served
the-
upon the respondent number 2.
Wait for a long time.
Under section 4, POCSO. And charges under section 4, POCSO.
So, my lord,
Yeah,
regarding,
yeah, that's true. Yes,
regarding appearance after receiving of the notice of 35(3), that is not material at this point of time after rejecting the bail petition by the petitioner by the trial court. my lord.
No, here my case is that whether his custodial interrogation is required
And
or not, because
that
he has
fact only will-
cooperated as per direction of the IO Lordship. And he is the authority who will arrest Lordship.
other day we saw a judgment, right? We said that it's a common misconception that, we all say that, we all say it. It's not the custodial direction. Actually, anticipatory bail
My lord,
considerations
yes.
go beyond custodial direction. It's a general bail.
Lordship.
right? The only thing I'm hesitating about interim is that submitting a false, if it's true.
No, but
At
otherwise
the
also
moment, we have
Lordship-
to go file a FIR.
Yes, but otherwise also Lordship, he has to file Lordship election petition if that regarding that false document. Because section 125A, that relates to Lordship submitting false documents and that representative of People's Act, it is clear Lordship that how trial has to be there. And Assam Panchayat Act is also there, that tribunal is there.
If document is disputed.
Yes,
My lord, at this
but
stage,
those
case diary
election
may be called
petitions
for.
were not filed within time, and beyond that period, now he has filed the present case Lordship.
The offense is serious, my lord, a public representative, my lord, he submitted
If
false
anything,
documents at this time of my lord, submitting his nomination.
For a few days, let's get the case diary.
Lordship,
Application.
if anything is there, he will face the
No,
consequences.
I'm just,
Lordship.
hesitating at this stage. Hold on for a few days. When can you get the case diary? Monday? Get it on Monday.
Monday, Tuesday,
Boko.
Tuesday, my lord.
Your Lordship, already he has cooperated and he is elected by ward member, he is not going to flee Lordship, only that part
Elected,
Lordship
my
may
lord.
protect Lordship.
How he is elected?
Otherwise Lordship can cancel my bail application
For
other.
the case diary of Boko PS case number 293 of 2025. Under section so and so, PNS read with 125A representative People's Act. We'll stop. Leave the matter on 411. Let's see. Next. 411?
Yes.
You said?
Public.
Haron. Maybe.
Lordship, my senior is another court minor, so at 2
After
p.m.
some-
only.
After some. 33. This one.
Maybe Mr. Lordship, I am appearing on behalf of L.R. Mozumdar, my lord.
No.
He is out of station, my lord. Kindly observe on port is there.
CD also not received. my lord.
Interim order is there. 5 to 10.
Interim assignment.
Yes,
Your
ma'am.
good- Your good.
Yes, my lord.
Your good name?
A Khalek.
A Khalik Learned Counsel submits that he's appearing on behalf of the leading counsel, L.R. Mozumdar.
Entire may continue. ma'am.
Who's outstation to this? He's outstation. So he seeks another day. The case diary is also not received, issue reminder. Interim order passed on it, 25/7/25. With regard to petitioner 5 to 10. Over now. Shall continue till the next date of listing. List on
14/11/24.
14.
Obligation.
34, my lord, case diary not received, my lord.
But FIR is at page 7.
Case diary is also not received.
Several times. case
Earlier,
diary was
earlier
called for
rejected,
motion.
my lord.
It is pending since August lordship.
Oh, why? Bongaigaon.
Bongaigaon.
Pathak sir, it passed earlier. This diary is not.
A short date may
not
be
being
given
received.
as a last chance lordship.
Learned Counsel submits that the case, petition has been pending for case diary for considerable time, praise for early adjudication. Earlier bail petition was rejected by by this court on 12/6/2025. Issue reminder for the case diary. List on
On, my lord,
6.
11/11, my lord. 7/11.
Can it be lordship except 7 lordship? Can it be on
Oh.
6 lordship?
6/11.
6/11, obliged.
May I please, Lordship? Lordship, this is second bail application, Lordship.
Earlier rejected by
Earlier
lordship, my lord.
Never mind.
Serious cyber.
Lordship, the FIR is in page number 13. Lordship, the allegation against the accused person is that they are operated illegal money transaction. Lordship, in this connection, in this matter, the FIR name accused person are already in bail. All the FIR name accused person. And the petitioner is not the FIR name, Lordship.
The FIR named accused persons are on bail.
On bail, yes, yes. One of the FIR name accused person, that is Amar Sharma, he is also allowed pre-arrest bail. Yes. The order is in page. The order is page 18. Yes.
Amarjyoti Sharma.
Yes, Lord. My humble prayer is to kindly allow the bail petition, Lordship. He will cooperate the investigation and he will appear before the IO as and when required, Lordship.
Updated diary is not
Yes,
received.
case diary received, my lord. Earlier rejected by your lordship, my lord. Police has arrested many other accused person.
This is
He
the
is-
previous order.
Yes. Your lordship may kindly
Page 21, from
Page
21.
21, my lord. He is the mastermind of the entire, my lord, racket.
13.8. Expert to Lolo, take it on to the left. Page 21 of the bail petition, expert to Lolo. To para 4. He submitted that earlier bail petition was rejected on 13/8/2025. The perusal of case diary, seen the annexed order. It is also submitted by the learned counsel, drawing attention to the annexed orders that several of the co-accused have been granted interim bail by this court. Anyway, so updated case diary is received. He's not FIR name, but he's said to be the
Yes.
mastermind.
Yes, your lordship may kindly peruse some of the statement.
You can also submit.
He along with other accused, mainly, my lord, there are, my lord, lots of, he is the mastermind, my lord, operating the entire racket, my lord. They are involved in collecting, my lord, various, my lord, accounts, those accounts, my lord. Actually, mainly, my lord, these are the persons, they are operating those accounts, some international, outside of the state, the link between the accused, they, my lord, after, my lord, collecting those, my lord, bank accounts, my lord, in the name of the sum of the invasion, there are also, my lord, evidence that they are involved in supplying those bank accounts to some of the, my lord, cyber offenders outside the state, my lord. Regarding that aspect also, my lord.
I perused the grounds of rejection in the earlier order. The learned additional PP on the basis of the
Because
updated
many-
case diary submits that the investigation has already found the present petitioner to be one of the mastermind running the entire rackets. It is submitted that the alleged offenders constituting the racket had also given the collected bank account details of innocent customers and given these to the to other persons indulging in cyber offenses. It's very serious matter than.
Everywhere regarding Saiful Islam, my lord, next portion also, my lord, there are. By using those mole accounts, my lord, they are involved in all these illegal transactions, my lord, in the name of operating some online.
The IO has also filed a detailed bail objection along with the case diary. I've seen the contentions made by the IO in the said bail objection. The IO strongly opposed to grant of bail. Stop. I find force in the contentions of the public prosecutor and as well as the that of the IO in the bail objection. I do not find sufficient new grounds to take a different view in the subsequent petition in favor of the accused. Accordingly, the bail petition stands reject. The investigation is also in progress. I got return back the case diary. Very dangerous matters. Of less.
May please your lordship. Previous bail application, your lordship. The FIR is page 10. Notice was served to informant, it was served. Page 10 is the FIR, your lordship. The allegation is serious, but the instruction in the case is not correct. I have stated paragraph 4 of my petition, page 4. The informant is the mother of the victim girl as per. He took rupees 5,000.
May I please, your lordship? My 483 bail application, 3263/25, lordship. Today is fixed for, but inadvertently it is out of list today, lordship.
You want to move it
But-
today? You want to move it?
Right,
You want to move the bail?
yes, lordship.
Today?
3263, lordship. Today, CD is available before this honorable court. Now, matter is very urgent, lordship. Considering the length of detention as well as
We'll try to-
medical ground, lordship.
Right, recommend. Second half.
It is not listed.
Not listed, my lord, today.
Not listed.
Not listed.
Tomorrow, let it come up tomorrow. Huh?
Okay,
Tomorrow we'll take it.
obliged.
Okay, Kali?
My lord, day after tomorrow would be convenient because tomorrow already.
Sorry, already,
Urgency.
already, yes,
Oh, yes.
my
Let's try-
urgency is
let's
that
try
I am waiting for bypass surgery, lordship.
Yes, yes.
Try for tomorrow, right? Try for tomorrow. Oh,
Much obliged.
Maximum punishment is 3 years for all the offense case registered.
Nice. Games and betting.
Not naming the affair, custodial detention may not be required. Because
Yeah.
households or church, nothing recovered, my lord. We have here next, the charge and seizure list, my lord.
This games and betting is this teal.
My lord, it's a double goody game, my lord.
Oh.
In the Lido area, my
Not
lord, they are running, my lord. It's like,
Earlier it was Jhandimunda in local language.
But this can be addiction, you know,
Uh,
especially if you win initially.
Yes.
And that is how people get sucked in.
Yes. Earlier, when you were young, we also used to play it, but especially during Diwali.
Consciousness was of law was also not there. And
Yes,
then
yes.
subsequently these things are came
So
to-
that's why the government has kept-
regulated.
The government has kept the punishment, that's why for 3 years. Well, I'll go and appear before the IO, record my
What's
statement.
the
I think this
materials?
is,
What is
Yes,
the
my lord,
matter?
we have received the CD, my lord. Here, my lord, as stated by my learned senior, my lord. Yes, admittedly, he is not FIR name, my lord. But my lord, during the course of investigation, my lord, they found that he is the person who is behind this, my lord, this organizing everything, my lord. And
So-
other people, those are the agents, my lord.
Oh.
And my
That-
lord,
that is- may not be justified.
yes, my lord, and from the, my lord, that is during the course of investigation, not only from the other co-accused, from the independent witnesses, they have also stated, my lord, that, my lord, they know that he is involved with for last many months. My lord, they have filed one objection, my lord, that is categorically stated entire thing. And they have that belief that at this stage, my lord, if he is, my lord, granted the PRS,
These are
my lord.
anticipatory, right?
Yes, my lord.
You see,
but here, my lord,
More
there is
people
no
will have
notice
a-
under section 35. my lord. But arrested, accused, all granted bail because saying that the punishment is only for 3 years.
it is found, if the materials indicate that he is one of the organizer, then may not be justified. So you know, if it was a regular bail, that's okay. I mean, let me see. His name is, what is his name?
Diamond Borwa, my lord.
Let's see.
Name also like diamond, spade, hearts. মা বাপের ঠিকের নাম আছে।
Till. Third Learned Senior Council, BD Quor, stood by for the petitioner, and K. Bosso learned additional PP for the state. The petitioner, so and so, is invoking provisions of 482 BNSS, seeking pre-arrest bail in connection with Margarita PS case number 101 of 25 under section 112 BNS, read with section 13/14 of the Assam Games and Betting Act 1970. The allegations in the FIR dated and so. FIR dated 18/8/2024 pertain to conducting a search upon getting information about going on of activities in the nature of double booty gambling game, which is violative of the provisions of the Assam of the Act enacted by the state of Assam to prevent these activities, prevent and punish these activities. Full stop. It is submitted by the Learned Council that the maximum punishment, however, is 3 years imprisonment. During the search, some persons were arrested and some material seized, including tickets, stuff. The present petitioner is not named in the FIR. However, the learned prosecution on the basis of the case diary submits that he has been found to be the main organizer of these activities, which cause a lot of financial ruin and domestic conflicts by involving various persons in such activities, in such addictive activities and stuff. I have gone through the bail objection submitted by the IO, in which the IO has contended in detail about the role of the present petitioner based on the investigation materials collected. And all the contentions and materials indicated in the bail objection on the basis of investigation indicate the present petitioner as the prime accused in these activities. Therefore, finding force in the state contention of the IO as well as the prosecution, it may not be prudent to grant anticipatory bail as investigation is still in progress. Therefore, the bail petition stands rejected at this time, returned by the case.
Look, there is one item number 18, it was passed over for the time being.
I'll take up.
A POCSO case.
Item 18.
18, one. Well, here the victim has been examined, cross-examined and again re-examined. And ultimately it came out that it was a consensual love affair since she was 16 years of age. That's why the accused did not marry her and she had alleged miscarriage and all, but in the evidence, nothing has come.
I'll just have a look. Only I'm back.
We have received the case diary, but still FSL report is still pending.
5 accused persons, no? He has been named, 5 accused persons. This bail petition is for one of them. Oh,
No, Your
three
Lordship,
of
for
them.
three.
3 of
Two of them were on interim, Your Lordship.
She was married to accused one, and then on the face of it, there are some allegations, but it remains to be seen. Diary has, what did you
Diary
say?
received, Lordship, but
FSL
postmortem report is pending for still FSL report is not received yet. And one's position, yes, multiple bluish colored bruise of varying size ranging of from 0.5 cm to 0.5 cm to 1.5 cm to 1 on both lower limbs below the knee. And witnesses were stating that, Lordship, and independent witness neighbors, Lordship, that there are frequent quarrel between the family members and she has tortured mentally and physically. That the witnesses were implicated petitioner, Lordship. And they have fled away from the place of occurrence from the date of incident, Lordship.
Yes. John Bibi, Halima Deva. Mother-in-law and who's the petitioner number 2?
Mother of her mother-in-law, mother of the mother-in-law.
Mother of the mother-in-law.
Yes, yes.
নকৰিলে তদন্তত সহযোগ নকৰিব আৰু সাক্ষীগণক ভয় ভাবুকি দি তদন্ত
You have translated also.
Yes.
This may not be a case of complete non-compliance, definitely.
My lord,
Brief, but reasons are there.
my lord, here, my lord, the case is that, what I understand is that, my lord, that is my lord, senior submission
Then
is that, what is my
if we
lord,
think, just give me 1 minute. If we hold that this is sufficient,
My-
though brief but sufficient,
my,
then we'll have to go into 37, I think, no? Commercial quantity.
yes, my lord, that is,
Let us go,
If that is not violated, madam, then commercial.
commercial, then.
If there is violation, even commercial also,
Yeah,
yes,
that your lordship.
Yes. We have been learning that too.
yes, my lord. Now, my lord, the contention is that, my lord, 47, 48 notice is there, but my lord, not in the detailed way, my lord, as stated in the FIR, these are not mentioned, my lord. Now, my lord, here the FIR is on, my lord, that is 23/4/2025. FIR is annexed with the petition in page 10 of the petition, my lord. Now, my lord, present accused petitioner, from whose home, my lord, after
Yes.
getting the intelligence report, my lord, they make the search and the contrabands were recovered, my lord, from his house. Thereafter, they
That one-
tried to find it out, and thereafter, my lord, after lodging of the FIR, he was arrested, my lord. And he was accordingly produced, my lord. Regarding, my lord, there is the service of notice, that is the 47 is, my lord, served. Same way the 48 is also served, my lord. And, my lord, he was produced before the, my lord, learned special judge, my lord, that is on that day, my lord. And that is also, my lord, I have flag mark, my lord. Now, my lord, here only the question is that because, my lord, the details as stated in the FIR, there is the whole story, my lord. That narration is not there. But, my lord, the reason, my lord, is there, my lord. That is the case, my lord. Now, in this regard, my lord, that is the whether it is sufficient or not.
That sufficiency question, you look at it from whether it will be sufficient for the person to know.
Yes,
Why
my-
has he been arrested
It
and
is
prepare his basic defense?
yes,
Full and meaningful.
Doesn't have to be this long. something-
yes, my lord.
That will depend on facts and circumstances.
Yes,
right?
my lord. Yes, my
We
lord.
have to be realistic also. right?
Yes, yes, my lord. And my lord, in this regard, my lord, that is, my lord, that is the landmark judgment of Bihan Kumar, my lord. And after that, my lord, another 2 judgments, my lord, who
Yes.
again, my lord, give light to the, my lord, that is the judgment of Bihan Kumar, the Honorable Supreme Court. And
Latest-
both in, my lord, the Kasi Reddy Upendra Reddy's case, and also, my lord, state of Karnataka versus Darshan, my lord. Here, my lord, regarding this part, my lord, because, my lord, Darshan is the latest one, my lord. My lord.
Takpis lagate আছে,
Kasi
Kashi Reddy.
Reddy-
given
Ka-
just-
Kasi Reddy is earlier one.
Huh?
Kasi Reddy is earlier one, there of the Darshan. Yes.
May 23.
Yes, but
Kashi Reddy I have given to your lordship. Paragraph, my your lordship fine, 19, 20, 27 and 28.
Just asking, in case we, suppose we.
It is stated
court thinks-
meaningful
Yes.
and purposeful,
Go
my lord.
go ahead. In case the court thinks that suppose this is sufficient, then 37 arguments, would you like to do it
If your lordship find it is sufficient, then 37 will come.
another day, today or another day?
No,
Because that will require some,
no,
looking
my lord, your
deeper.
lord, on the face of it, whether it is violation or not. If your lordship is not satisfied,
If you ask me frankly, that, we have to be realistic also.
Yes,
no,
my lord.
We have to
but
be-
law, my lord.
If my lord kindly,
Keeping, the law which laid down by the Supreme Court.
No, I am not saying, the,
That true, my lord. He has been informed, but information is sufficient.
I'm not going into substantive compliance. Substantive compliance is not the governing law despite darshan in terms of, because it's a previous decision.
my lord.
But even if I say that prima facie, I am finding it difficult to say that this is not sufficient.
My lord, that is the prosecution,
grounds
my
are
lord,
there.
submission is there,
Grounds
my
are
lord.
there.
That is, it is the,
Grounds
my
are
lord,
there.
my lord,
This is one case where, it is in local language, grounds are
and
there.
also my lord
Brief-
sufficient.
Brief, but grounds are there.
Yes, my lord.
And-
It is a ground, that one will also to see, my lord.
So,
And my lord, that is supported, my lord.
I
That,
find
my
it
lord,
difficult to throw it away straight away.
yes, my lord. And my lord, in this regard, my lord, that is, my lord, may
Unlike
kindly
those other formats
produce
where
the
nothing is
production,
written.
production order, my lord. This is a production order, my lord. To more light to this, my lord. What is the purpose of this, both the notices, my lord? 47 and 48, my lord. He was arrested on 2/6/25.
Doctor
my lord.
already discussed by this division with this honorable court also.
Yes.
That's all, my lord.
Yeah, that's, now we are governed by the earlier decision. Despite your vast experience, I mean, this is law keeps on changing this thing. So, particular case, yes, this,
So these
Yeah,
are
I-
interpreted, doctor also interpreted in this.
yeah, I found another decision that they have some Ladakh something, the Supreme Court has said
Oh.
about this principle, that the subsequent, the earlier decision in point of time will have to be considered.
But the only if also see when the paragraph 19 of that Keshireddy. Paragraph 19.
It should be in, see, what I understand, subject to correction, is that all these foundational judgments of
My lord.
Purkasto and
My lord.
Vihan Kumar, it
My
says that the reasons have to be specific to the person and in sufficient detail to enable him to know
Yes,
why
my
his liberty has been cut.
Yes, my,
And also to help him prepare his basic defense.
yes, my.
That's right.
That is the satisfaction.
Yes,
And
my,
then
This-
that criteria,
my lord.
nobody can put it in a, iron cast straitjacket.
Yes, my lord.
It cannot be standardized that only 4 lines will do.
My
or
lord.
10 lines have to.
My
no,
lord.
It will depend on.
My lord.
That will not
And
do.
that will, my lord, reflect in the production order, my lord. What is before the special judge, my lord, what is after his production, my lord, what things have come out, my lord. My lord, may kindly peruse, my lord. The purpose of this notices, my lord. So that he can defend him, my lord. No prejudice.
Just what is
to
one
be there.
paragraph 19 of the Reddy, my lord. 1 line. Of the Keshireddy, my lord. On information is something else, my lord. Reason something else, ground is something else. The paragraph 1920.
Earlier, we used to think that reasons and grounds of arrest are same thing.
Not same.
No, we used to think
Ah,
something
exactly.
conventional.
Earlier,
Once upon a time, we used to
but-
think,
but
this is how
after-
law
yes.
evolves. We used to think,
it only
and
has
now we
come,
know that it is different.
now it has come only because Article 22, my lord. That was not earlier pleaded. Paragraph 19, 20 and 27.
Like charge.
Yes, not meaningful and bereft of necessary
is-
essential information.
This is the only thing, man.
So,
Simply information will not do.
that will, in my opinion, in my humble opinion, to determine in a particular case whether it will be sufficient or not, it will also, it will involve an objective as well as a subjective determination to some extent. But anyway,
Paragraph 27, 28 also, my lord. Same. Objective. Object underlying the provision that the grounds of arrest should be communicated to the person arrested has been very so-and-so Vihan Kumar on learning about your lordship. 27. That just now you already mentioned that he is to make a representation.
yes, yes.
My lord, from that Kasi Reddy, my lord, what my learned senior, my lord, stated, my lord, I am on that, my lord, itself, my lord, another para of Kasi Reddy, my lord. Para 27.
Yes.
I have just given.
You want to read?
Yes, my lord, that is, my lord, the object, what I
Yeah.
am stating, my
I
lord,
have
that is a
just
para
referred.
27, my lord.
I-
May I read, my lord, that only that?
You can.
Yes. The object underlining the provision that the grounds of arrest should be communicated to the person arrested has been very succinctly explained in Bihan Kumar Supra on learning about the grounds of arrest. The person concerned will be in a position to make an application before the appropriate court for bail or move the High Court for a writ of habeas corpus. Further, the information will enable the arrest person to prepare his defense in time for the purpose of his trial. For these reasons, it has been provided by the Constitution that the grounds of arrest must be communicated to the arrested as soon as possible. So, my lord, that is the, my lord, the para 27, my lord, of the Kasi Reddy, my lord. Now, my lord, in continuation to Kasi Reddy's case, my lord, what is in, my lord, Darshan, my lord, because Darshan's case, my lord, discuss both, my lord, Kasi Reddy and, my lord, Bihan Kumar, my lord, because it is after, my lord, Kasi Reddy.
The Dishon. Darshan was distinguished in another case just recently discussed, madam. That was for cancellation of bail, Darshan, madam. And it was discussed in this court. Another judgment is come, madam, just a few days back, madam.
My lord, only,
That
only,
was-
my lord, that, my lord, point, my lord, regarding this point, my lord, only one para, my lord, from Darshan, my lord, that is, my lord, 20.1.4, my lord. In Bihan Kumar versus State of Haryana, it was reiterated that Article 22(1) is satisfied if the accused is made aware of the arrest grounds in substance. The word is used, my lord, in substance, even if not conveyed in writing. Similarly, in Kasi Reddy Upendra Reddy versus State of Andhra Pradesh, it was observed that when arrest is made pursuant to a warrant, reading out the warrant amounts to sufficient compliance. Both these post Pankaj Bansal decision clarify that written individualized grounds are not an inflexible requirement in all circumstances. And before that, my lord, that is 20.1.3, the constitutional and statutory framework thus mandates the arrested person must be informed of the grounds of arrest, but neither provision prescribe a specific form or insist upon written communication in every cases. Judicial precedents have clarified that substantial compliance with these requirements is sufficient unless demonstrable prejudice is shown. Now, my lord, in this case, my lord, both 47, আপনার দর্শন of course.
Darshan to nahi, my lord.
My lord, in
Darshan has been revised in so many other cases, madam.
my lord,
On 14 October, there is a judgment I have just given, madam.
Anyway,
yes, my lord. Our, my lord, submission is that, my lord, judge, that, my lord, that is the 47, 48 notices there. It is not, my lord, in earlier way, my lord. They have given, my lord, that is the gist, my lord, for which, my lord, the person was arrested, my lord, that part. And, my lord, along with the production order, my lord, if, my lord, kindly peruse the production order, that is on, my lord, 2625, my lord, when he was produced, my lord, it is clearly stated regarding, that is the service of the notice, not only the service of the notice, my lord, that for his defense, my lord, he stated one of the name of a learned counsel who is engaged by the, my lord, that is the petitioner, my lord. So, my lord, that is a sufficient compliance is there. He get every opportunity to defend his case before the, my lord, learned special judge, my lord. So that is my humble submission, my lord. That is the purpose of that 47, 48. And as such, my lord, that is the, my lord, right guaranteed under, my lord, Article 21 and also, my lord, 22. That is not infringed in this case, my lord. That is my humble submission, my lord. Otherwise, my lord, the rigor of Section 37 is there, my lord.
Either the learned senior counsel and or you,
My lord.
You have not yet entered 37, right? So what
My lord,
should be-
37 part is that, my lord, I am not entering, my lord, because in details, as because, my lord, that is, it is, if the case is, my lord, it is a FIR dated, my lord, 23/4/2025, and the CS is on, my lord, 4/9/2025, my lord. So, my lord, now this case is, my lord, on the stage of, my lord, that is the trial, my lord, is going for that, my lord.
Charge has been framed.
Charges yet not framed, my lord, but
Not
yet not failed, my lord, because, my lord, CS dated 4/9/25, my lord. And, my lord, yet not framed, my lord. Here, my lord, 6 numbers of PWs are there, my lord. 6 numbers of PWs are there. And the contrabands, that is, my lord, 4,070 numbers of Yaba tablets, my lord. those were my lord, contrabands were seized from the house of the, my lord, that is the accused petitioner, my lord, that day. Or otherwise, my lord, if my lord fixed for another day on that point, my lord, then you can go through, my lord. And also, my lord, at the same time, my lord, that is the present status of the case that may be also, my lord, called, my lord.
Should I do that?
Up to your lordship, but if your lordship feel necessary, my lord, otherwise, my lord, this is on the face of the record, my lord. If you require, I have nothing to say, my lord. But so far this case is concerned, my lord, whether it is sufficient or not, that is only your lordship is to see, my lord. If that is there, 37 will not come, my lord.
Yeah, that's true. 37 will come only if it's,
Only my lord.
we have to go into merits.
Exactly so.
Merits.
Exactly so.
Third, learned senior counsel, HRHO, accepted by IU Chaudhary, learned counsel, the petitioner. The learned senior, the petitioner invoking 483 BNS is seeking regular bail in connection with Mankasar PS case number 64 of 25 under section 22C29. He was arrested on 2/6/2025. The gist of the allegation was about a recovery of significant quantity of suspected psychotropic substances in the nature of Yaba tablets. Yaba tablets, this one?
Yeah.
Yaba tablets or this Mitha?
My lord, that is the methamphetamine is the thing, my lord, that is the
Yaba
component in
tablet.
FSL, my lord. The Yaba tablets, my
Yaba
lord,
tablets.
4070 numbers of Yaba
Containing
tablets.
Mitha. From the premises, 4,000 in number.
It is 400 grams, my lord. As per FIR.
4070 number of Yaba tablets.
Amounted
of
400
weighing
grams.
400 grams.
Including 6 grams of envelope. That is how it is written in the FIR. Anyway, about 400 grams.
The prima facie, the quantity of the contraband falls in a bracket of commercial quantity and hence such provisions have been given. Thereby, the test of section 37 of the NDPS Act has to be seen. However, the learned senior counsel at the outset has addressed his contentions primarily with regard to the notice under 4748 BNSS, when relying on the settled position of law by now contends that perhaps the said notices are inadequate, thereby entitling the petitioner to bail. On the other hand, the learned additional PP referring to the scanned case record submits that the said grounds of arrest are sufficient in the instant case and cannot be said to be violative of the constitutional mandate. In the notice under 47, the grounds of arrest are narrated in vernacular within bracket Assamese language, and so also in the notice under 48. The same may be reproduced here in translate courses of cross check reproduced here in
Could we furnish translated copy, my lord? Yes, sir.
Translate there. The learned prosecutor has referred to, the learned petitioner counsel has referred to decision of Rihan Kumar and Kasi Reddy. Kasi Reddy, you have preferred?
My lord,
Both sides.
Both sides, my lord.
Kasi Reddy.
I am also relying Kasi Reddy also.
Judgment, NIA versus Hangman Mehte. Support of their respective contentions, apart from the leading judgment of Rihan Kumar. The learned additional PP has drawn attention to para 27 of Kasi Reddy Supra, which may be reproduced here in the
My lord, along with Kasi Reddy, my lord, there is Darshan also.
And also para 20.1 of State of Karnataka versus Darshan.
My lord, this is 20.1.3 and my lord 20.1.4.
20.1.3,
1.3, my lord,
20.1.4.
20.1.4, both the paragraphs. And my lord, 20.1.5, that is also no.
20.1.5. What emerges from these principles is that that grounds of arrest in reasonable detail and specific to the accused person will have to be furnished to the accused as well as to his nominated or related nominated person slash family member, so that they are apprised of why his liberty is being curtailed by way of arrest, and also to enable preparation of defense on his behalf, especially the question of bail initially. How much details would suffice to meet the constitutional mandate and the legal principles laid down by the Honorable Supreme Court would obviously depend on the facts and circumstances of the case. In each case, the court perhaps may have to make a determination as to sufficiency of these grounds in the backdrop of the settled principles. For the same purpose, coming to the instant case, I once again peruse the grounds of arrest, so the grounds in the two notices. Though they are brief in nature, but I'm of the considered view that they would suffice for the purpose of meeting the standards necessary of these two notices under 47/48 DNSS. I'm also of the considered view that while the constitutional mandate in terms of reasonable details have to be fully complied with, but at the same time, the contents of the notices also should not be held to a standard of impossible hyper-technicality. Thus, I come to the considered opinion that on the grounds of violation of procedural standards at the time of arrest, the petitioner in this case would not be entitled to bail. In view of such a determination, now the question of Section 37 will have to be seen as in cases involving commercial quantity. The court will be statutorily permitted to grant bail only if the test of Section 37 is passed in favor of the accused. So should we keep it another day? I think that would be fair enough. You prepare it because today you have not seen it.
My lord,
You have
my
not seen
lord,
it.
my lord.
From
Any
this
another date, my-
perspective. you
Yes,
need-
my lord.
There may be materials, but
My lord.
they didn't
My
try. So.
And
so we'll
also, my lord, next
part
day, my
out-
lord, there is status of the, my lord, status may be also called.
However, the learned counsels and the learned defense counsel as well as the learned prosecutor may address arguments on the applicability of Section 37 on another date. Meanwhile, a status report regarding the stays of trial
Yes,
may be procured from
my-
the learned trial court. Which is the learned trial court? Mankasa? Mankasa? Thoughts?
Special.
Special judge.
Special judge.
Data for this.
This will have to be, not necessary to keep it part heard because I have made a determination.
Yes, my lord, that part is complete, only
That's why I-
rest is there,
I did not-
rest is remaining. my lord.
I love
My-
paragraph কিখিনি উঠাব লাগে এইটো আমি দৰ্শনৰ চব নালাগিব পাৰে in principles.
Judgment লৈ লও।
Is the matter on?
Next week হৈ যায়।
Any date as my.
Next week বস্তুটো আহিব, তুমি খবৰ লৈ দিব পাৰিবা না?
No, sir, raised to any person.
Oh, record in the from the registry.
Status, through raised.
The date.
Scan copy.
One week there.
Scan.
One week will do, my lord.
7 or maybe
3 months.
Monday after that.
13 November.
7 or 10,
So no, one more
Ten.
question is for the record is to come from
Yes,
that.
my
yeah,
lord,
right.
yes.
10, 10.
10.
10.
So it will remain part or no?
No, not necessary.
My,
Not necessary. Because I have not gone into 37.
my,
This is resolved,
my lord,
rightly or
my,
wrongly.
my lord, my lord.
But this law is evolving.
Yes, my lord. My lord, it is evolving.
Problem is when Supreme Court is getting problem.
No, it is evolving.
Because today one thing, Doxon also has been decided, so many judgment come after.
It's good actually. This 22 was always there. We always knew about DK bus was always there, but
RDA Amendment 22 already used in respect of preventive detention, my lord, RDA.
preventive,
Now it has been brought here. my lord, this is the problem.
with the march of the current society, the march of liberty should also go. No, that is
Yeah.
the hallmark of a
Yes, my lord.
advancing rule of law and developed society country.
Yes, my lord.
That's good. Some people will get bail because of earlier, because the
Yes,
IOs
ma'am.
not know. Let them get bail. Doesn't matter.
Yes, yes, my lord.
They will learn, but they
But
should
it is
learn.
evolving, my lord.
If
From
today I
that-
make a mistake, it will not be justified as
Yes,
an IO.
my lord.
I should know.
Yes,
this.
my lord. Yes,
Main thing is trial.
yes, my lord.
May I please, your lordship? Lordship, it is a 482 application, lordship. Lordship, pursuant to court order dated 10th August, lordship, I have appeared before the authority, lordship. My statements have been recorded, lordship, and I have submitted the relevant document. Lordship, actually, there are due to some misconceptions, lordship, this FIR have been registered, lordship. There is a background in this case, lordship. If you, lordship, allow me, first of all, lordship, the background is that, lordship.
Barriers come.
Yes, case they receive.
Lordship, the background is that, Lordship, in the year, Lordship, 1997, 1998, Lordship, the Ministry of Tribal Affairs, Lordship, established a school, Lordship, in the name and style of, Lordship, Ekolabya Model Residential School, Lordship, in Lordship, tribal area, Lordship, basically for the poor and the tribal people and orphans, Lordship. Since, Lordship, the BTAD was not inserted in the 6th schedule, Lordship, at that particular point of time, Lordship, said school was not established in Assam, Lordship, in the BTC, Lordship. While the BTAD was inserted into the 6th schedule, Lordship, a revised guideline was published by Lord in the year 2000, Lordship, 10 by the Ministry of Tribal Affairs, Lordship. And Lordship, that Lordship, that guideline, Lordship, revised guideline, Lordship, vested responsibility upon the state, Lordship, to opt for suitable, Lordship, mode of management, Lordship, which
Of
I
these
have
schools.
for the school, Lordship, which I have annexed in my petition, the page 20, Lordship, page not, Lordship, annexer, Lordship, B, page 19. This is the revised guideline 2010. And Lordship, the relevant part is at page 22, Lordship. Page 22. It is, yes, issued by the Ministry of Tribal Affairs, Lordship. Lordship, the Z, point number Z, Lordship. A management committee may be constituted for each MRS which could include, amongst other reputed local NGOs involved with education. Help of such NGOs may be taken to organize socially relevant document welfare extension programs, Lordship. So, Lordship, NGOs, Lordship, state government responsibility, Lordship, vested upon the state to up, Lordship, this NGOs, Lordship. Education relates to the, relating to the academics. Lordship, there is an NGO in the BTAD, Lordship, namely, Lordship, Bodoland Model Tribal Education Society. This is a, Lordship, a registered society, Lordship. And Lordship, this society, Lordship, established, Lordship, Lordship, the school, Lordship. And it was approved by the, Lordship, Minister of Tribal Affairs Department, which reflects in my my second petition, Lordship, page, Lordship, 11 and 12. Second petition, page 11 and 12 of item number 32, Lordship. Lordship. 11 and 12, Lordship. 11, this is the starting, Lordship. Committee constituted by the NGOs, Lordship, and submitted before the, Lordship, government, and it was forwarded, Lordship. This is the communication, Lordship. Last line, Lordship. This has the approval of both Honorable Minister and Commissioner and Secretary, WPT, and BC Department, as empowered by the revised guideline, Lordship. Then, Lordship, may kindly come to the page number 12. Okay, come to the page number 12 or item number 32, Lordship. Lordship, this is the inspection report, Lordship, of the year 2014, Lordship. After that, Lordship, the NGO, with regard to the registration of the NGO, which is at page 26 of item number 31, Lordship.
31
page 31, Lordship.
of item.
Item 31, Lordship, page 26, Lordship. This registered NGO, Lordship, which have been approved by the Minister and the Tribal Affairs Department, Lordship. Lordship appointed the.
Model Tribal Education.
Lordship, this NGO appointed, Lordship, the principal and other staffs, Lordship. Lordship, which is, principal's appointment letter is, petitioner's appointment letter is at page 27. Page 27, Lordship.
Got.
And accordingly, Lordship, the school is going on, Lordship. In the year 2019, Lordship, the Ministry of Tribal Affairs Department, Lordship, formed NEST, Lordship, an autonomous organization in the year 2019, Lordship, which necessitates to, Lordship, issue a fresh revised guideline that was issued in the year 2020, Lordship. 20 notification also I have NS, Lordship. Revised guideline 20.
I found it.
So it empowers the NEST. It empowers the NEST. After the formation of the NEST, Lordship, formation of the NEST, Lordship, district level EMRS and the state level EMRS were, Lordship, constituted, Lordship. And after that, Lordship, the Deputy Commissioner directed, Lordship, the President and Secretary, Lordship, to hand over the charge of the school to the Lordship, the district level committee, which is at page, Lordship, 55, page 55, 13/7/2023, 13/7/2023, issued by the Deputy Commissioner. And responsibility was given to an additional Deputy Commissioner, which is at page, Lordship, 56, page 56. Those two persons, Lordship, hand over the charges. And then, Lordship, may kindly come to the page number 57. Number 57. By way of this letter, Lordship, the additional Deputy Commissioner, Lordship, makes me the custodian of the school, Lordship. I have not removed from the school. Till that, Lordship, I am rendering my duties as, Lordship, the principal of the school. Now, Lordship, what happened, Lordship? While funds have started to come, Lordship, some politics involved, Lordship. And accordingly, Lordship, challenging one, Lordship, approval, government approval, Lordship, I filed a petition, Lordship, being a principal of the school, Lordship. On the motion day itself, Lordship, the council for the, Lordship, Tribal Affairs Department, Lordship, submitted before the court, Lordship, I have no locus standi, Lordship, I am fact, and accordingly, Lordship, the Honorable Court, Lordship, directed the CID, Lordship, to submit a report, Lordship, whether I have been appointed by, on 2 points, Lordship, whether I have been appointed by the NEST and whether the Bodoland Model Tribal Education Society was authorized by the NEST to appoint me as a principal, Lordship. On the, that was, Lordship, on 13/6, Lordship, 13/6, Lordship. On 23rd/6, Lordship, report submitted by the, Lordship, CID, Lordship, stating that, Lordship, I have not been appointed by the NEST, and, Lordship, Bodoland Model Tribal Education Society has also not been, Lordship, empowered to appoint the principal, Lordship. In fact, Lordship, I was appointed in the year 2000, Lordship, 13, Lordship, 13, and NEST formed in the year 2019, Lordship. Question of appointment and authorization does not arise, Lordship. And, Lordship, challenging that, Lordship, and followed by that, Lordship, report, the Honorable Single Judge, Lordship, in the writ court, Lordship, directed the CID to register the case, Lordship. And accordingly, Lordship, this case has been registered, Lordship. And, Lordship, while I challenged it for our Honorable Division Bench, Lordship, in the meantime, Lordship, case was registered, Lordship. And I got the case number and the section of law from the Honorable Division Bench, Lordship. This is only my case, Lordship. There is nothing illegal, it is, Lordship. And, Lordship, one more thing is, Lordship, time to time, Lordship, inspection report are also been submitted, Lordship, in this regard, Lordship. Subsequent inspection report is at page, Lordship, page 74, Lordship. Submission of status report, it is, Lordship, is inspection report, Lordship.
So,
It is-
this, Angelus.
Angelus Baxter, Lordship, Angelus
He's
Baxter.
the principal.
Principal, he's the principal, and in item number 32, Lordship, Ramakanto Mosari and Harakanto Mosari are the president and secretary of the Lordship, society, who has already given and hand over the charge, Lordship.
Okay.
The
Yes,
sub
my lord,
status rupees made kindly be
My lord,
paid.
case diary received, my
Little
lord.
complex, you know.
Yes, my lord,
Understood,
complex
no,
issue. It
but
will-
not fully.
Yes, I am
But
not going into the detailed
This
history
is
of
that,
the,
case was directed, this.
yes, yes.
Then
thereafter.
after, because he was running it
Lordship,
unauthorized.
Yes.
Lordship.
Executive.
This is, I have not removed.
My lord, I will point out, my lord, briefly, my lord. Regarding that, my lord, present item number 31 is the principal of that, my lord, Ecolabba Model Residential School, and 31 and 32 is the, my lord, president and secretary of that, my lord, Bodoland Model Tribal Education Society. And regarding the present petitioners appeared before the IO after obtaining interim, their statement recorded, and their statement is available in the case diary, my lord. Regarding, my lord, in this case, during pendency of a writ petition, my lord, this Honorable High Court has raised 2 points, my lord, on that, whether the principal of the Ecolabba Model Residential School, Dolbari District, Baksa, has been appointed by the National Education Society for Tribal Students. And secondly, my lord, regarding whether the Bodoland Model Tribal Education Society, where, my lord, petitioners are the president and secretary, my lord, has been given any authorization by the respondent number 2, that is National Education Society for Tribal Students, to run the affairs of the said school. And regarding that, thereafter, my lord, an inquiry committee was, inquiry was conducted, my lord, and during inquiry, as per the, my lord, query of the inquiry officer, the reply she has received, my lord, that, my lord, the National Education Society for Tribal Students did not appoint any principal for EMRS Dolbari, Baksa District, Assam. So, my lord, National Education Society has not appointed any principal for that, my lord, Ecolabba Residential School. And secondly, my lord, NAIST has not authorized any NGO to run the affairs of the EMRS Dolbari. So, my lord, that NGO, wherein the petitioners are the president and secretary, they are not authorized by the NAIST for running that Ecolabba Model Residential School. So these are the questions, and my lord, during inquiry report, there are, and thereafter, my lord, as per the direction of this honorable court, this present case has been registered, and the present case has been received.
No principal appointed, and secondly, no
not
such
authorized.
authorization to the society was given.
Yes, yes.
I have already submitted that point, Lordship.
Okay.
Lordship.
That is the case, my lord, apparently run by the
I
unauthorized
have,
person.
I have, my statement have been recorded thereafter, Lordship.
As there appears to be a primary case of sitting in unauthorizedly running the Ecolabba Model Residential School, Dolbari, and taking fees from children by giving the impression that he has been given the authority to run the said school. So these are the content. Thereafter, on the basis of that, my lord, inquiry is going on there. The thereafter petitioner obtained interim protection. Their statement is available in the case diary. And regarding that aspect, my lord, thereafter last portion, one, your lordship may kindly peruse that there was a long history of the case. They could just only how they are involved in, my lord, illegally, my lord, running that school by the NGO president and secretary of the NGO. Your lordship may kindly.
I not have the time to
Oh, yes.
see it, but anyway.
Anyway, my lord, they cooperated with the investigation. Otherwise, my lord.
We will cooperate, Lordship.
So in a sum and substance, there was no authorization.
There is no authorization, they illegally, in fact, my lord, I just would like to point out this aspect of the investigation, because they, in fact, my lord, illegally trying to occupy a building which was, my lord, constructed by.
A lot of money is also
Oh, yes,
substantial.
yes, my lord, that is the,
Crore.
yes.
Actually,
Lots
Lordship,
of financial, my lord,
Cheating, in what sense it's been given, the students?
students, my lord, both.
in this regard, Lordship, there is report, Lordship, Lordship.
And
That was a false allegation, Lordship.
which report?
Report from the Inspector of School Services, which is at page 74, Lordship. Time to time, Lordship, reports were furnished, and that allegations were raised, Lordship. This is the latest
Lordship report prior to Lordship handover the SAS dated 29 January 2022 Lordship.
74 of your
74 of Lordship, item number Lordship 31 in my additional affidavit Lordship. Additional affidavit, item 31 Lordship. Lordship. Categorically stated Lordship. Present status of the school Lordship, space.
Otherwise, my lord, everything is illegal, my lord. The authority by the society has no right to, my lord, appoint any principal.
Right now, not
And
Lordship,
if
but
they have appointed, my
earlier-
lord, otherwise they have no authority to run that school, my lord.
Actually,
Actually,
Lordship-
here I am just pointing out to this, my lord, report because, my lord, they in fact trying to illegally occupy the, my lord, legally constructed building, my lord, of that Ecolabia model residential. Otherwise, Ecolabia model residential school is there. That was run by the, my lord, under the my lord,
Ministry of
authority-
Tribal Affairs.
Yes. my lord.
Lordship.
This, which inspection report you wanted? to
Lordship,
see?
page,
Page 70.
page 74 Lordship. Page 74 Lordship, inspection report Lordship. Page 75, 11 part Lordship. Para number 2, EMRS Society. Borderland Model Education Society is a registered society. The society was registered by the government of Assam under Society Registration of so and so, dated so and so. The Honorable Minister, WPT and BC, Commissioner and Secretary approve this society this society is running the EMRS till now. That was the finding. And Lordship, regarding Lordship misappropriation, Lordship, there is also, there is a finding Lordship which is at page 77. Additional information sought at Directorate, WPT and BC Assam. Regarding collection of students, education fees, admission fees from the guardian and undersigned, the undersigned made the principal of EMRS teaching and non-teaching staff, students from class 10, 9 and 9 to 10, 12, even the parents and the pass out students separately. They were asked and interviewed randomly and the same statement was received in written. As per statement of the principal, teaching and non-teaching staff, students, parents, even pass out students, it is found that no fees, visualize admission, tuition, game, common room, library, hostel, development, etc. have not been collected during admission, collected during admission. The management of the EMRS is the Borderland Model Tribal Education Society. During my verification, it is found that the society has not taken any kind of fees from the guardian and the parents, as informed even records of receipt copies were not found to prove by the students, parents and the guardians.
Yeah, we have gone through that.
That's it.
Anyway.
Lordship, and Lordship, prior to Lordship establishing the Lordship constitution of Lordship state level MRS and the district level MRS, there was no illegality Lordship. It was run as per the revised guideline 2010 Lordship. Next Lordship, home in the year 2019 Lordship, which necessitates to issue a fresh guideline in the year 2020, June 2020 Lordship. And thereafter Lordship, we have hand over everything to the district level EMRS. Our statement have been recorded, Lordship. And till that, Lordship, the petitioner have not been released from the post, Lordship. He has been authorized by the Deputy Commissioner, Lordship.
Continue.
Lordship, continue, Lordship.
Anyway, so এইটো অলপ লিখিব আগৰ পেন 7 এইটো AB 1588 পেন 7 of first paragraph, second paragraph, third paragraph. Case diary has been received. The learned counsel for the petitioner addresses his arguments in which he contends that also heard the learned additional Mr. P. Bothakot, who submits that though the pursuant to grant of interim, the petitioner has appeared before the investigating officer and their statements are available. But the materials reveal that the school was run unauthorizedly. Will that be correct to say that they were running the school unauthorizedly?
They, otherwise, there's no authority from the NIST
Anyway,
for running of that school.
conclusion, I will.
Yes,
in the chamber.
principal was.
While Just look at it little bit. Today only.
Yes, Lordship. Obliged, Lordship.
এখন থৈ যাব।
Lordship, one more aspect, Lordship, I would like to submit before Lordship. Lordship, may kindly, Lordship, in paragraph number, Lordship, last one minute, Lordship, paragraph number 13 of my petition may kindly be perused, Lordship, page 8, Lordship.
13 of.
13 of
which
Lordship,
petition?
item number 31, Lordship. Paragraph number 13, page 8, Lordship. I have categorically stated why the observation is not correct, Lordship.
I'll see.
Obliged, Lordship.
I was in 30 minutes. Like this, 36. English? English. কোনটা আছে 2000? Please. Two was.
May I please, your Lordship. Lordship, before going to the marriage, Lordship, as per office note, Lordship, the notice was sent through the concerned OC of the Juria police station, Lordship, and the track consignment could not be ascertained because that was sent through the OC. And as on last occasion, this honorable court was, on previous occasion, this honorable court has granted us the liberty to take steps through the concerned OC for service of notice upon the respondent number 2. And because on earlier occasion, the postal receipt remark came that addressee could not be found. And Lordship, this petitioner before your Lordship has assailed the impugned judgment passed by the trial court as well as the
Check bouncing case?
no, Lordship. The judgment as well as the judgment passed by the appellate court whereby they have been sentenced to undergo 1 year imprisonment. And Lordship, against that, they have preferred this revision petition, Lordship. And while preferring this revision petition, there was a delay of 523 days. But in actually, Lordship, there is no delay. And this petition has been filed in the month of May 2025. And Lordship, till date, state has not filed their objection, Lordship.
What about, let us clear this service aspect.
Yes, Lordship.
Tulsi Saikia was the informant.
Sorry, Lordship.
Tulsi Saikia was the informant.
Yes, Lordship. Earlier appeared before the trial court, recorded statement, cross-examined, but in the appellate court also, they did not turn up.
Show fresh notice to Julia Police Station. They were asking for the track consignment.
Yes, but as per office note, Lordship, track consignment could not be availed because it was sent to the officer.
The police station.
Yes, but their track consignment should have been there to my limited understanding because that was sent by registered post or my learned friend may also obtain instruction.
The
And
delay is on the higher side, so it will be.
yes, Lordship.
At least.
But
give them an
Lordship,
opportunity.
if for a moment, Lordship, the actual from the depth of knowledge, there is actually no such delay. Because the earlier one of the accused person who was pursuing the appeals and Lordship, he died in the year 2020 during a pendency of the appeal. And the learned counsel who was appearing in the appellate court, that was my ground, Lordship, but
I'll go into that person.
And punishment is of only 1 year. So if lordship delays condone, I don't think the respondent number 2 will have any have to
okay.
suffer.
Just trying to complete the procedure.
Yes.
So what did you suggest?
Last, my lord, what notice may be served, my lord? Otherwise, my lord, punishment is yes, only 1 year. That is
No, the process.
process.
This through Juria police station, it was not, sir.
No report has arrived, lordship.
PS Juria. Resident of Nagaon. You took instructions.
Yes.
Kotaku, you took instructions. But you did not get instructions, right?
No, that was not.
Or it was not directed.
Yeah, not directed on our request, also matter was
He
taken
has
up.
not also served, my lord, notice, sir.
Auxiliary devotion to register. Could be looking for registry for check on
Sir, lordship, I'll get the instruction, my lord, if he has.
Only difficulty, lordship, though I am outside, lordship, police is searching me, lordship. And
Yeah, why? For undergoing the sentence?
yes, lordship.
No.
And if lordship pleases, then no coursive, that observation is if there lordship, that no coursive action shall be taken against me, lordship, during finish of the
Criminal
present-
revision, he can also will take step by registered AD also.
That was taken, lordship, that was taken on earlier.
It was taken. It was came back answered.
Answer.
As
Thereafter,
address, insufficient address.
Yes,
Thereafter, it was to police station.
yes, sir. I will try to get
And
the
that,
instruction, my lord.
after taking steps through officers of Juria police station, that thereafter the completion has not arrived. As to whether it was served by the concerned police station or not.
Your grounds have been given in from para 5, no? Onwards?
Yes, lordship.
Mention that one of the persons.
From para 5 onward. Para 5 to 8, lordship. Illiterate persons, lordship, they are day-to-day labor, lordship, waging their livelihood by way of daily labors.
It's about 1.5 years of delay.
Actually, lordship, to be very fair enough, lordship, they were not aware what happened to their appeals. When the police was searching them, then only they came to know that their appeal got
I forgot
dismissed.
about it actually.
That is the difficulty, lordship. That's why they were sitting for all those days. From the judgment of the trial court is apparent, lordship, there is a civil dispute between the parties, which kept the color of this instant FIR.
Anyway, at this stage, what can be done?
Your lordship, otherwise, your lordship, delay may be
It's a bit on the higher side actually.
higher side, and this is the difference.
Notice is also not served.
Yes, your lordship, I will get the instruction only last.
Lordship, till then, if lordship pleases,
yes.
I could not.
Can
If
it
lordship
be
please-
given such kind of, because it's a revision, because
Revision,
revision is not
this
yet.
is the-
been-
that is the
Can I
difficult
give
thing.
if I can
Give my
give?
lord notice unserved.
I'm willing to give, if I can, it will not be incorrect to give a direction for not resorting to coercive measures, will it be correct? Because the
That-
revision is not yet admit.
Yes, yes, that is the difficulty, not yet admit.
Substantial justice.
Yes, lordship. Otherwise, this is 1 year imprisonment, and for some days they have already undergone the jail before the trial
Let him
commenced.
take one fresh step, my lord. Fresh step, then.
The instant interlocutory application has been filed invoking section 5 of the Limitation Act, seeking condonation of delay of 523 days in preferring a criminal revision petition.
Police station lawyer আছে,
In bracket filing number 1767 of 25 by the 4 applicants here. Agreed by the the concurrent findings of the learned courts below in convicting and sentencing them to imprisonment, which is stated to be of 1 year. 1 year.
Yes, yes, Lordship.
Stop. Though the informant has been impleaded as respondent number 2, but service is pending. Earlier registered, notice by registered AD came back unserved. Subsequently, notice was sent through the Juria police station, but no instructions has been received. The learned additional PP shall take instructions regarding the service upon respondent number 2. And fresh steps also, we'll take fresh steps.
Yes.
Will you
Fresh
take?
steps, yes, sir, that may be, and fresh steps in correct address, if I will try to ascertain some correct.
The applicant petitioner shall try to gather the correct address of the informant and take fresh steps. In this case, in that case, you leave it to and get the tracking.
Yes, yes, Lordship.
Tracking.
Lordship, tracking actually difficulty, Lordship, we have to submit the steps to the
Yes,
registry, and
they have to procure.
registry have to.
They have to procure.
Bring
That
the.
I understand. Nowadays, ADs don't. come.
Yes, Lordship.
State it.
In trial courts also, it doesn't.
Out this. Technology. Though the revision is not yet taken up for admission and adjudication. But the aspect of condonation of delay is being looked into. And matter is tied up at for procedural steps. Therefore, it will be in the interest of justice to direct that till the next date of listing, coercive measures may not be taken against the applicants. With regard to, you give the number, case number.
Yes, Lordship.
With regard to
With
GR case
regard to
number
Lordship.
40, GR case 409 of 21,
Yes, Lordship.
2011.
Yes, Lordship.
And criminal appeal number 27 of 19. GR case pending for learned JMFC Nagaon. And it will appeal to learned additional session judge number 3 Nagaon. This will do.
Yes, Lordship. Repeal.
List the matter on after a month or so.
Oh, yes,
It's a delay.
on 19th of November.
1911.
How less, Lordship?
Parliament. এইটো কোনটো আছে এইটো 53 আছে 2 52 How should we go? You guide? Should I
Yes.
take orders?
Yes.
Admission?
52 কোন session?
That time, your lordship,
That
that-
we can, that's part heard, I think. But it's not mentioned as part heard.
no, it is my lord, your lordship fixed the other day, that we wanted to see the judgment of the Supreme Court. Your lordship, what I have given, it is there or not, my lord? If it is not there, we can supply one. We are so that we say,
কিমান নম্বৰ এইটো?
the bail pending appeal.
52.
2 years, 1 month, 16 days, my lord, 326,
Total conviction is?
10
Sorry,
years.
total
man.
sentences?
Yes, 10 years,
3 years,
10 years, man.
10 years, for 326.
Yes,
Oh. Yeah,
I-
it's
your
punishable up
lordship-
to life.
yes. No.
No, 326.
326.
For tribal by magistrate.
Yes,
State has already filed objection.
yes, yes.
Fine.
Your lordship, whatever, it is there or not, my lord? That does it.
Section has not come into record, I think. It should be there.
Objection to file করেছিল।
তুমি কালি এই মহিবুরটা দেও না।
Oh,
We wanted to say that judgment of Supreme Court might have just.
in this case, 2 have been granted bail.
Yes, yes, man.
You can say.
That was 1 year at that time, man. And at that stage it was rejected, my. So I just relied on this, your lordship's order, my lord.
We'll rely on Supreme Court judgment. Well, objection, I'm not finding now. No, it's the court. On merits, I'm asking.
Merit, I am not on merit now, my lord, because hearing, there is no chance of hearing, my.
Yeah, there are more
That's it.
prosecution,
Yes.
objection come on as well.
Objection not pointed.
দেখতে যাবে না সেদিন
Uh-huh.
সেদিন বসেন বসো
I found.
Yes, sir.
তুমি তো সব অফিসার ছিল
I've gone through, you
Yes,
refer to the report.
yes. And regarding the Milord, the present Supreme Court, already two persons, your lordship has
Yes.
granted bail, Milord.
That thing is in
Uh,
favor of the petitions. Two have already been granted by the judge.
on the length of detention.
Yes. Mommy, it was page number 14 of the IA. It was another order 13/8/2024. It was facts to law, HR children, same of it, listed value children. And so, but the second paragraph to law is second, third, fourth. Total and law. Altogether, how many persons were convicted?
Three.
So 3 persons. I see. By this order, by the order dated 13/8/2024, passed by coordinate bench of this court in IA 1027 of 25. In criminal appeal number. Criminal appeal is already of 2023.
Yes,
Uh,
23, man.
Two of the three convicted persons, namely Sarve Sali, last 13 paragraph of top, and Badsha Mia were really released on bail after suspending their sentence. The learned, with regard to, that means only Rohim Ali is here.
Yes.
No?
Rahim, your lordship, when order dated, wait, please. Rahim Ali, 3% Rohan and Sharbesh were granted bail.
Yes.
No, sorry, Sharbesh 2 and 3,
2 entries.
2 and 3.
Two and-
Sharbesh and Batsa.
However, the bail of the present applicant was rejected at that time. And accordingly, he has come before this court with the present interlocutory application seeking suspension and sentence, sentence and bail as well for him. The learned senior counsel submits that he is not going into the merits of the matter at this stage. And seeks suspension of sentence and bail with regard to the applicant on the ground of on the aspect of parity with the other two applicants, and also in view of the possibility that the criminal appeal may not be disposed of in the immediate future. The learned prosecution represented in this case by additional PP P. Borthaku has filed a written objection where the deportations of some of the important witnesses, including the victim, have been discussed. It is stated in the bail objection that there's that the appellants have been rightly convicted and that prima facie there is no infirmity in the judgment of impugned judgment of the learned trial court. Would you like to submit something?
Regarding, I would just like to only regarding that Supreme Court, regarding only 2% granted, you will regarding this person.
The factual part.
Yes, the appeal against conviction is of the year or one line only, the appeal against conviction is of the year 2023, which is not likely to be heard in near future. So, my lord, which is not in all cases, suppose in a particular case,
If you
it cannot
fix
be
it, it will
said
be
that,
heard.
it cannot be said that every case will be,
No.
cannot be heard, will not be heard in near future, my lord. If some cases, my lord, one other remedy is there, that appellant may file an application praying for early hearing.
Yes, yes.
Suppose-
Early hearing.
And if that early hearing application is suppose, my lord, not considered, then, my lord, in that case, my lord,
Yeah.
petitioner, yes.
These things are there. actually.
Yes, some
things
things
are there.
is there.
These things are there. You know, as I have
Things are
said
there.
earlier.
Normally, madam, even 19 cases till today pending, madam.
90.
18, 19 case pending, man. Till today, man.
Otherwise, my lord,
And Anand is aware of that, man.
without
No, I don't know
disposing-
that. I don't have
my
statistics.
lord, otherwise, without disposing of that IO appeal, in some cases, my lord,
Yes.
I am not
No,
saying in
just-
all cases.
But normally it is
Considering
not
the,
coming.
my lord, gravity by, considering the, my lord, gravity of the offences, my lord, in some cases, early hearing that can also be
Can
fixed
also be fixed.
in some cases.
But this is rejected 1 year back, man.
There has to be. How long is
2 years, 1 month, 16 days.
stop?
That's
The
all.
learned additional public PP supporting the bail objection also contains that it cannot be said definitively that there would not be immediate prospect of hearing of the criminal appeal. Full stop. And that the aspect of the gravity of the list of gravity of the offences also need to be looked into. Full stop. The learned senior counsel representing the defense submits that after the conviction and sentence, the applicant hearing has spent 2 years.
Yes, 2 years, more than 2 years, man.
2 years, 2 years. and
2 years, 1 month, 16 days.
Approximately 2 years, 1 month, serving out the sentence. Next paragraph. I've perused the materials and given my consideration to the matter. On the aspect of suspension of sentence and bail, which stands on a different footing than conventional bail matters, dash W. There are catena of decisions of the Honorable Supreme Court governing the subject. However, in one of the decisions, it still holds the field. The Honorable Supreme Court has indicated and observed, indicated that in non-life sentences, perhaps the question of execution of sentence can be looked at somewhat liberally per se. Full stop. Of course, it would also depend upon the facts and circumstances of each case. A recent decision of the Honorable Supreme Court in the case of Kartik Pandit, the state of Jharkhand, has been placed, wherein the Honorable Supreme Court was pleased to grant bail pursuant to suspension of sentence. Ultimately, we'll need a clearer policy. I'll tell you this thing. There are many laws, many laws in these things actually, because in mechanical interpretation can also be risky, but nevertheless, the senior counsel is right also. In this case, there's a special thing to have got.
Yes, to.
The instant matter cannot be overlooked that 2 out of the 3 convict appellants have already been granted bail pursuant to suspension of sentence. Full stop. In the normal course, there may not be immediate prospect of in the normal course, it would be difficult to say as to when the turn of this particular appeal will come up for hearing. In the absence of particular statistics before this court. Full stop. Therefore, in the entire facts and circumstances, and also considering the aspect of parity to some extent, it will be prudent to grant to allow the interlocutory application. Execution, suspension, execution of the order of sentence dated so and so, passed by so and so.
Additional Session Judge FTC North Salmara over
North Salmara in
Sessions
case number
42 within bracket capital A/2016.
cross check it. Is hereby suspended till the disposal of the criminal appeal, and the applicant convict appellants are allowed to go on bail of rupees 75,000 at a to the satisfaction of the concerned learned court, trial court. The following conditions are imposed. The conditions can be order to deal order common condition. Can go on bail.
In appeal, my lord, yours. Are you disposed?
I allowed and disposed on the aforesaid terms. Any order has to be passed in the appeal also?
Yes.
Just come up to them.
It will come for hearing.
Appeal, yes, the last order. On appeal to the appeal has been already admitted on 13/8/24.
LCR also received.
LCR, TCR is available. This is the matter for hearing in the usual course.
Yes.
Obliged.
The statistics that we need, I've said earlier also, statistics that we need is how many criminal appeals are there. You know, when we go to a doctor, sometimes what we ask,
Today,
how many patients have gone? You know,
Today,
Yes, right.
today 2 items came 15 and 16, court number 18, ma'am. Item number 26, 27. 15 and 16 appeal, ma'am.
So that's the thing.
Anyway.
We can get the statistics. So how many matters are there? What is my number in the queue?
Yes.
And that is a very important statistics.
Yes.
And I can jump the queue also, like speedy
Yes.
hearing, but I have to give a reason. Isn't?
Yes.
Doctor also same, somebody is coming with an emergency.
Regarding.
May I please, your lordship? On the earlier occasion, it was 2310, the amicus curie was appointed, but the matter is not listed yet, Lordship. It was fixed today, Lordship.
Okay, now.
So
that we have
can
taken
it
up-
be tomorrow or after
This is
tomorrow?
the matter.
Yes,
But my
bail.
lord, here I have gone through the LCR, the 164 statement of the victim is not available. See,
Grounds and reason of arrest, Lordship. Page 16, Lordship.
Yes, I am on 16 only.
May I read, Lordship? Lordship, during course of investigation from the reliable source, it came to know that the below named arrested person found loitering near the PO on the date of occurrence. Lordship, then next, during preliminary investigation, it has come to light that his reputation is not good in his locality. Most of the local people suspected him to have involved in the crime against proper cases over the Eleka. Lordship, he resides in the near downtown, about 2 kilometers far from the place of occurrence, Lordship. Nothing has been recovered from my possession, Lordship. Lordship, yeah, on the length of detention, I may allow to go one ball. 60 days period, Lordship.
How many days?
Today 56 days, Lordship, today.
But we don't have anything to support our business. Then diary is not available.
diary not
I
available.
think diary will be necessary in this case.
Yes.
We don't know, he may be involved also. He may not be. In that case, it is unfair.
On your lordship, maybe short date, my lord, on 31.
31.
Lordship, actually, Lordship, fact is that Lordship, police not arrested me, Lordship. Yeah, 1/9/2025, the petitioner went out for daily working. And at that time, he was on darkened mode. And accordingly, the co-worker called the Dispur police and handed over the police, Lordship.
Otherwise, it's a case of robbery, right? A lot of valuables have been stolen. We don't know. So it will not be safe. Case diary, the learned counsel seeks bail on the length of detention of 56 days.
64 statement is
Yeah.
happening.
900.
So
I don't know.
the allegation is about. Allegation is about house trespass and the robbery of valuables, including ornaments. So the accused was, I've seen the grounds of arrest. The case diary not available, issue requisition for the same. Dispur PS,
Dispute,
you
yes.
can get it. no?
Yes,
31,
31.
30, 31,
30.
31.
Lordship,
It's not 31.
130, Lordship.
But 30, 30 or 31?
Yes, 30, my lord.
But
আমার কিছু হবে না।
Oblige.
So 30, my lord, if not come, then again he will be in difficulty. So 31 would be convenient.
not serve any purpose. otherwise.
Oblige.
Just break law now.
My lord, in my case, the case was fixed on 14, my lord. Whereas in one case, 164 statement already is there. In other case, out of the same FIR, my lord, already 164 statement is there in the BA. And in AB, no other statement is required.
Which matter you saying, sir?
Production.
Scan copy at night of 164, most I should say question.
Oh, sir. That matter.
Yes,
Yeah.
my lord, scan. No, I have checked, but
It's not there, no?
Scan copy, my lord, 183 BNS.
Neither of the petitions not there.
Yes, not.
That's
there.
what you said.
And
Yes,
CD is
get-
also, my lord, statement of the.
A short date may be again because 164, 5 date is there, my lord. Petitioner in custody.
Which date you gave?
14/11, my lord, 11/11, my lord, I can.
Is it okay? 11/11. I don't know. You work out the date. I have no problem. You work out the date.
No, already fixed on.
Lot of
14.
matters. No matter. Short date, we are always tight, no? So much load. We have to increase capacity. 11/11.
Yes.
Give me a break. Let us finish whatever we can, remaining time. There are 3 hearings also.
Well, before that, I would
Transfer
like to,
petition is also
I would like to make some small clarification, my lord, regarding item number 35.
Mhm.
Your lordship, that is the cyber offense, your lordship already was pleased to reject the bail petition. Item number, today's item number 35, my lord.
Okay.
At the time of my lord passing the order, your lordship has stated that these accused persons, my lord, taking the bank account by using the bank account of the innocent person for their illegal transaction. But those accused, those persons are not innocent. Your lordship may kindly not use the word innocent
okay.
because they are taking commission, my lord, from those.
No,
those
so other persons,
Other persons.
the connected persons.
They are taking commission from this.
That's, you've gone into detail,
Yeah, yes,
I for detail.
because
Whoever লিখেছিল,
they are providing their account.
Other persons,
They are providing
other
their
account holders.
They are providing their account on commission basis. They are taking commission for
Good.
that.
What will be the appropriate expression then? Other account holders.
Other account holder, they are also not
Other
innocent.
persons.
They are also involved along with them
Other
because
persons.
they are providing their account on commission.
Other person. সেইটো কাটি দিব। Order.
May I please your lordship? My lord, there is an IA along with the criminal appeal, my lord. IA is for suspension of sentence to grant bail till the disposal of the criminal appeal, my lord. The sections are 350, 1 IPC and section 8 of the POXO Act, my lord. The max.
Criminal appeal order. This also, Boyso, just a minute. The main criminal appeal pertaining to the other matter, earlier matter.
My lord.
Main criminal matter also notice is pending. Main criminal matter is also notice is pending. So
Yes, well, in earlier one, my lord.
earlier one.
Yes, my.
So
My lord,
Mr. Singh,
they are also, my lord, the same order, my lord.
same
Same order. my lord.
service upon informant slash respondent, private respondent, not yet complete. The prosecution shall take instructions. This is the matter on 10/11. The orders called along with the connected IA. 42.
My lord, here, I filed this petition for vacating the interim order.
Okay.
The case is this, my lord.
Clarification. In the
but-
transfer petition.
Yes, the case is this, my lord, they issued a say, two say. And we deposited in our accounts at Mongoldo. And it bounced. Then we filed a case in Mongoldo as a jurisdictional place. Now, they filed this petition for sought for transfer of that case to Porpeta. Their ground is that they filed, there is a title suit, they filed, and that title suit I am also a party. This is the ground. But so far as title suit is concerned, it is run at their own whims. But so far as the this case is concerned, complaint case is concerned, that jurisdiction place is where the check is presented. I place under one judgment.
After all the confusion.
All the yes.
Settled.
Yes. Law is settled.
Normal jurisdiction is, transfer is some subject to.
Yes,
come up.
yes, sir.
You know,
But I'm a lady.
Facts different, but
Yeah.
natural jurisdiction will be first at the place where.
Place where the
check
check is present.
Bounce.
Yes.
Check is.
Check is
Check
bounced.
bounces.
And when
Check
this-
bounces, checks to bounce
and
at
then-
Guatemala.
And then I
Access
place,
Bank, Guwahati.
I place one judgments.
Bridgestone.
Supreme Court judgments.
Bridgestone.
So my eyes, there was a check at Mongoldo in my accounts. So there the check has been bounced.
Dasrat, this Rup
Yes.
Singh Rathod, that had created too many limbs.
Yes.
It could be filed everywhere. So that was the amendment was brought.
Yes.
And then
My lord.
Bridgestone upheld that amendment.
Yes. But judgment is
Refresh myself.
clear, madam. The recent judgment, hello. This is the only fact. Now,
Just 1 minute.
and 2005 judgment was to come, but I have not get that order judgments.
What is the 2005? This is a recent document, 2016, comparatively recent.
Yes.
Anyway, continue. Please continue.
So, my lord,
This is the only grounds. Their grounds taken that title, they filed title suit and that title suit were the parties. So we should go to Barpeta. That case is to be transferred to the Barpeta. So but as far I am is concerned, I am a lady, my lord. I am residing in Mongoldoi because I was earlier married at Barpeta district. My husband died. After died of my husband, I residing in my father's parents' house.
Is the, this, order, stay order?
It is, by certificating petition, I filed it, my lord.
Your submission?
Page 8, my lord. My indelible obligation, page 8. Entire proceeding is held, so entire matter is disposed of to itself, my lord.
She's from her paternal house is
Eh,
Mongoldoy.
yeah, Mongoldoy.
She was married earlier in Barpeta.
Earlier in Barpeta.
Now she's staying in.
Yes.
I'll come to you, sir.
My lord, in this case, first up, I will submit. The Mongoldoy court has no jurisdiction to try this suit. And the complainant has no right to file this complaint case by supplying the relevant facts. The jurisdiction of the court under section 138 comes where the check was bound, returned, dishonored. To check in this case, madam, complaint petition may be perished. Complaint petition is page 15.
I'll need the other file also.
Main transfer petition. In transfer petition,
transfer.
page 15, my lord.
It will agree.
Page 16, page 3, a complaint petition, my lord. In this case, my lord, page number, paragraph 3, with the help of the good relationship with the complainant as well, the family of the complainant, the accused persons took a loan of rupees 15 lakh from complainant on 2/11/2022 for urgent need of money of the accused. Complainant paid the said amount to the accused due to good relationship. Now, page 4, my lord, after repeated request, the complainant, the accused had issued two numbers of checks against the said loan amount to the complainant on 18/7/2023 by check number so and so and the check number so and so. Both checks are dated 18/7/2023 and the both checks were drawn at Axis Bank at Hangrabari, Guwahati, my lord, as branch service Guwahati against account of this accused account, my lord. So cash was placed for collection. Droi Bank is a Axis Bank. So Honorable Supreme Court, in full judgment, it is decided, it is 2014, that in a check dishonour case under section 30, cause of action arises in different place, but the check where it was dishonored, that is the jurisdiction of the court. And the place that can be considered where the check was also issued. But the main, the Honorable Supreme Court, in the full bench decision, my lord, 2014 9 SCC. And this copy is important, my lord.
29.
Clearly, 2014 9 SCC, paragraph 17, my lord.
What is the name of the case?
I have one copy, my lord.
Darsara,
The full bench clearly decided.
not for it.
Single bench decision is not prepared. Jurisdiction only the regional bank. So Mongoldoy court has no jurisdiction to tie the suit.
So this is the Dasara Roop Singh Rathod. You know, after this judgment, there were a lot of complications. Whereafter, this amendment was brought in. Right? 140.
But jurisdiction,
Amendment was brought in.
jurisdiction, my lord,
Amendment was, discussed in this Bridgestone.
Roy Bank and the SEC where the complaint received from and the accused person handed over. to them. So as per section 177 old section, my lord, it is also mentioned clearly. Old section, my lord, 177 and present Bharatiya Nagarik Sarkar Act, my lord, 197. Ordinary place of inquiry and trial. If the offence shall ordinarily be tried into and tried by a court within first local jurisdiction, it was committed. So CIAC was issued at Barpeta. And this CIAC was placed, Roy Bank was Guwahati. So, my lord, the jurisdiction under section 30, I come, Roy Bank, not with other bank. Otherwise, where from the CIAC,
It was, the account, the check was issued, just a minute.
CIAC was from Barpeta.
The check was, I want to talk to you. Yes, I want to talk to you. The check was issued in your name and you.
I deposited in my account at Mangaldi.
Mongol.
But I am a permanent resident of Barpeta district. I never went to the Mangalore.
No,
So
no.
I never handed over this check to the anyone. It was the land sale agreement, my lord. It is clearly stated in title suit, my lord. This is admitted
That is
fact
separate
that there is a land sale agreement transaction, land agreement consideration money. Not alone is another thing is this, my lord.
You kindly come to negotiable instruments account level. Yeah, and you let us look at 142(2). You know, this is the jurisdiction issue. Wait, one NA.
My ground was that I cannot appear before Mangalore court. I am a permanent resident from Barpeta, regularly appearing Mangalore. How I can appear with my advocates? I have no any known person at Mangalore
As I
court.
said, no, that is first we have to see where the natural jurisdiction is. one.
My lord.
And once the natural jurisdiction is identified at a particular place, then
Once-
the
once
next
even-
question can come that it's due to some great inconvenience, it can be to another court. So first, let us see where the natural jurisdiction would be, right?
National section 177, my lord, 197,
142.
New Act, my lord.
2. This was the amendment, 2015 amendment, after Dasarath Singh Rathore. Dasarath Singh Rathore created some confusion. And thereafter this amendment was brought in, right? So do you have the act? Should be here also in the judgment. 142(2), subclause A. In case of account pay check, it will be at the place, it's very clear. In case of account pay check, it's very clear. At the place where the payee, that means the person to whom the payment has been made, he maintains his account.
Yes.
You know, where he presents, where it is dishonored, that will be the branch. But what is the meaning of the second? That if it is bearer check, then in this case, it's an account pay check or bearer check?
Check is here.
This is A is very clear, I have understood, but I still have a little bit of
Bearer
confusion with regard to B. In case of bearer check.
Bearer second.
But as we understand now, that now what we have understood now, subject to correction, is that after the amendment and the judgment of Bridgestone, it is at the place where it is bounced.
But your lordship can see page 21 is the set of the petition, complaint petition. 20,
20?
page 20 of the complaint of the petition. should be account pay check.
Account pay check, yes.
Account pay check, my lord. So we deposited in my account at
Mangalore.
my Mangalore. Naturally, and then I am a lady, I filed the case at Mangalore. And the petitioner is a persons, he belongs to Barbeta. I am a lady, I am living in Mangalore. Whether he got difficulty to come Mangalore or I will get difficulty, my lord. I am a widow. It is very difficult on my part to move Barbeta in every day.
True.
My lord, that cannot be the fact.
So
Case
what should
number-
we do? Can we trying to dispose of the
This
entire
is
matter?
entire matter, today, your lordship already gone through it, dispose of it entire matter, my lord. We have no objection. Already your lordship gone through the matter, point is clear, my lord, whether complaint filed at Barbeta has a statutory jurisdiction or not. This is the only point. If not, it will go to, then the case to be transferred to Guwahati, not Barbeta, my lord. Because his maintain his check at Guwahati.
Yes, that can be, Guwahati can be transferred, my lord,
And
because from Borpata I can.
Because they say that they maintain their account in the Axis Bank Guwahati.
Yes, my lord.
He issued the check on Axis Bank of his Guwahati branch.
Guwahati
branch,
You
right.
deposited it in Mangalore.
I deposited in Mangalore
Your
because
branch.
in my
your
branch, yes,
Bounce there.
bounce there.
No, bounce, check was bounced at Axis Bank, yeah, from here. That was only the place for collection. That was the bank. My lord, and apart that, page number 37, my transfer petition may fail.
Just
This has been suppressed.
page number 37.
37, page 37, original transfer petition. Annexure 5 may be finished.
Give me two.
This, the no objection certificate, this certificate
Page.
is belongs of the company, page 37. Original application, my lord, transfer petition.
Page 37 of the town. No objection certificate, certified that.
No objection, the resident permanent, their complainant is the permanent resident of Borpata, my lord. Damalzar, Borpata district. So check was issued from that place, and she received it. Another thing is this, my lord, civil suit, your lordship will file. It is clearly stated, civil suit is pending. The check money was drawn from Borpata district, and she also took another check, my lord, from her account from Borpata district. So all transactions were taken from Borpata district. Now, page 6, para 6, my lord. Paragraph 6, page 40. This cannot be denied. Another check, that the defendant, number 1, page 40, my lord, is a title suit, my lord. 66, 2024, that the defendant number 1 took another amount of rupees 2,40,000 through bank account transfer, check number so dated demand from the plaintiff through RTGS as advance money in terms of the agreement. So this fact is suppressing by the petitioner in this applicant, my lord. Page 38, this is a title suit. She cannot deny. This suit she cannot, liability she cannot, because she entered into agreement to sell the plot of land. That suit is pending in the court of civil judge, senior judge and Borpata. She cannot avert this liability because all transaction here, 2,40,000 already she has received. This fact also suffered on 4/11/2022. After issuing this check, my lord, how she can take this money?
You filed a written
From
objection.
Borpata.
My lord?
You filed a written.
This suppress this
Where?
fact.
Have you filed a written objection
Yeah.
on the transfer petition? No.
Complaint.
Yes, I also filed affidavit, my lord.
My
My
lord,
lord, you'll also kindly see, the title suit filed,
Complaint
Barbara, it
for
is different
submission,
footing,
my
my lord. I will I may appear there, may not be appear there. It will own course, my lord. That will not link with
You
that, my
must
lord.
appear because you have executed agreement, land sale agreement. There are
Let
civil
him complete,
suit
my lord.
is-
Let my friend.
Two
complete.
civil suit is pending, my lord. That is sufficing by the applicant. my lord.
Where is the subject question of surfacing, my lord?
Yes.
I will go there. I will go there. I may go there, may not be go there. I will come here for transfer of that case. I advise my client to transfer those file petition, transfer petition to bring those titles to Mongol, my lord.
My lord,
I will advise my client also.
my grant was.
I will go.
my
I will
gra-
file the transfer
My
petition.
grant, my lord, humble submission, my lord. The ground on my petition will perish. 11 page, my lord. Para 17. Para 17, para 19. These are the my grounds. First of all, para 15, these are the grounds why I compelled to file this petition for frequent transfer. I am a permanent resident of Barpata. So I have all the transaction was done at Barpata. CA were taken from the Barpata. And my Brave Bank was from Guwahati. I have also residence at Guwahati. I can, so all this transaction, my lord, from Barpata, I am a resident of Barpata, this accused person cannot be dragged every day for appearance or regular trial where Mongol day. Because at the time of transaction, this complainant was a resident of Barpata. Now, entire facts, maybe Paris Miller is surprising the relevant sections, this application. There is no any whisper, my lord. She was residing in Barpata in the complaint petition, my lord. But learned friend, surprising all this fact, that after death of my husband, I am residing at father's place. It is completely false. No such spreading mentioned in the complaint petition, my lord. We have the trial court. Trial court in the people trial court, she said, I am a permanent resident of Mongoldoy. I am living at my father's house since birth. So it is completely false, contradictory statement, false statement, and filed with the affidavit, my lord. This petition itself is not maintainable because paragraph 4, my lord, this IA, paragraph 4 is completely false because the applicant now, your lordships, but disclose that after death of my husband, I am now started deciding. But on which date she left Barpata, not mentioned. But this fact is also not in her complaint petition. All these are fabricated facts prepared in this IA, my lord. This may be period, all the placards. No such whisper that she even lived at Barpata. All transactions showing at Mongoldoy. She is showing permanent resident at Mongoldoy. So, misleading facts before your lordships in IA. She never came 2019 after left because Annexure 5 I have already shown that she is a resident of Damalzar, Barpata district. Why is the proof that she is a resident of Mongoldoy? No such any document because she is a resident with her children residing in Barpata, my lord. She never left husband's house. All her property, own house is Barpata. So, entire fact in this application, my lord, complete false. So, my Samuel submission is section 177, old section, where originally transaction was committed at Barpata, land sale agreement was committed at Barpata, and my ground was that this accused person cannot be dragged to Mongoldoy every day with his advocate appearing in a trial for conviction. And I have no any known person or any advocate or for taking bail from Mongoldoy court. I am a prime minister of Barpata. How is it I can appear before the Mongoldoy court, my lord? Then the dual bank is the cause of action, my lord. In inactors, at least cash can be transferred for convenience of both the parties before trial before at Guwahati, my lord. at least at Guwahati or Barpara. So I paid for Barpara, transferred to. I cannot appear from Barpara every day. I cannot be drug. I am a accused person. Every day I cannot appear with the advocate from Barpara. See, inconvenience is there. I have no any known person at Mongoldoy. I never went to Mongoldoy. No any person. I have no also bailor at Mongoldoy. How I can be compelled to face at Mongoldoy court for getting bail from Mongoldoy court? Is it my offense that I have committed? I am issued. I have admitted my lord. Even I have filed an application to settle the matter to pay the intern money, with condition that title suit have to be settled. First off, because title suit between the same party pending at Bafra Civil Justice Court. For excessive offense of contract, my lord.
So, my lord, my friend complete. If you complete, I will start, my lord.
But we have
Then
time
my
constraint also.
yes,
We have time constraint.
yes. My friend take more time, my lord, much time. Illogistically see, it is not necessary to mention in my complaint petition than where, but now I am residing in Mongoldoy, my parents' house, because after death of my husband. I clearly mentioned in paragraph, so far as suppression fact is concerned, titles I already mentioned in the title suit in my petitions. I already mentioned 62 title suit number 62 of the 2023 pending in
But
Barbara.
66
I mentioned, and another title suit mentioned, if I got notice, I will go there, my lord, no problem. Yeah, if I can also file petition here for transfer of this case to Mongoldoy. I am arguing, please. Then, my lord, illogistically see, those facts are not completely different. Title suit filed by the difference footing, Cheng Pang's case is difference footing, my lord. So let the trial is going on. I being a leader, a widow, no income, nothing, my lord. How can you go to Barbeta? And it is my better place where my maintain my account in Mongoldoy. I deposited the check there. So, my lord, interpretation may be dismissed. The trial is going on. If the title suit, my client, I advise them, they may file transfer petition. If they go there, no problem. They can file here also. I have no objection.
Anyway,
Interpretation will be disposed of, my lord, and whether allow or reject, I have no objection.
well, it will be disposed of.
My lord, interpretation. Yes, my lord.
Approval, I go. Theoretical. So I to do the.
I will march that petition.
One council.
Main petition disposed of, then I will know.
The matter. Arguments closed. Has been resolved. Other matters we'll have to mention only.
High level list.
এখন থব দে লগাই।
Next.
My lord, in item 70, there is an interim order, my lord. There is interim order till continue until further.
Interim orders will be, all interim orders will be continued.
Item 17, my lord.
Not your fault, it's not reached.
May
17.
17 until further order, my lord.
May it please, my lord.
An interim order, next date of listing, something like we usually give. Next date-
Until further orders, otherwise, my lord, I have to extend day by day, my lord. Always.
Really,
17.
until further orders to the contrary.
My lord, regarding
17, item 7.
supplementary hearing, my lord, this matter has been appearing since years, my lord, has not been disposed of. My lord, that may kindly be
Supplementary
fixed.
item,
47 and 48. Huh? Daily list, supplementary hearing.
748.
Yes.
We had a old
A
transfer.
matter may be fixed on 11th November, my lord. The matter was once hard, my lord, but due to some technical point, that matter has been pending now.
Oh. Okay,
On 11, my lord, I have some difficulties. Another,
it can be.
on
Choose
20,
another date.
2011, my lord,
Is it
At 2 p.m.
2011.
2011, 2011, endeavor would be made to
At 2 p.m.
take up the matter at 2 p.m.
Highly obliged.
My lord, item number. To section 2022-23.
My lord,
May it
item
please,
number
my lord.
15.
My lord,
Worship-
item number 43, my
43.
43, my lord.
Hmm.
My lord, POXO matter, my lord. My lord, my lord, the steps upon the amicus has already been appointed, my lord. It's
Mhm.
reflected in the cause list as well. Date may kindly be fixed, my lord.
Paucity of
Three-
time, list on.
My lord, tomorrow, my lord, or day,
Not
day after, day after.
Don't take it on 30, I have some constraints.
My lord,
Fix it next week, you take. next
third,
week. Take it on 6th, I would say.
6th, my lord, I won't be in Guwahati.
You won't be in county.
7th,
7th, but it's a motion day. Okay, 7th,
My lord, I am
I'm so
praying.
obliged. my lord.
11th will be okay for you, 11th.
11th,
Tuesday, hearing day, more chance actually. Otherwise, you take it on 6th, you cannot, no?
6th, 7th.
7th or 11th, as per your choice.
7th, if it pleases.
7. For the-
Item 43.
My lord,
If
item
you-
You
15.
have,
43 only, your lordship.
Yes.
Just a copy may be furnished.
copy you furnish. You have?
Yes, for PC.
Oh,
Yeah, so.
My lord, item 15. Worship, we have made it mention, worship, can it be taken up on 10th of November, lordship?
I can fix it.
10th of November.
Lordship, with regards to item number 45. Lordship may fix it in any other day as per convenience of this court. There is an interim order in this matter. So interim order may be extended, Lord.
The next date of listing, 45. Is the
Item 14, your lordship. There is an interim.
Interim order is there.
Yes.
Extended till next date of listing. When should I fix it? 13? 13, like, randomly I'm saying.
It is regarding item 45.
13 is Thursday, hearing day. Better.
Okay.
Lordship, regarding item number 13, your lordship, can it be fixed day after tomorrow at 12, your lordship?
Day after, again, I say I would request you, because I have some constraints. And on 30, 31, I have some constraints. What is the matter? Criminal petition?
As for washing,
Washing,
yes,
It's
washing
not
of charges,
reaching.
your lordship.
not reaching, no, that's the
Yet
problem.
not reaching.
Take it on a hearing day. Take it on a hearing day in the, starting from, not this week, next week onwards.
On 6th,
6th or 13th, 13th you take. 13th,
13, 1,
13th or 11th,
11th, 1.
Admission fixed
30.
Also the orders are also
13.
service complete, so admission correct. May it please.
item number 13, 13, 11. We are fixing randomly actually, should be fine.
Actually, it's preaching, it has come a lot of.
May,
This is a problem.
may it please, my lord.
Yes,
My lord, the item 43 which I just mentioned, my lord, service has been completed, can it be fixed in admission column? Date was already fixed by this honorable court.
admission column.
To be listed in the admission column. 43, yeah, deeply obliged.
Mix up with your-
Lordship, just now I mentioned the item regarding item number 45.
45.
Your lordship, item number 14.
It's separate. My one was
Yes.
separate. She intervened, so I clarified that it was regarding 45.
We'll mix up otherwise. 45 you have mentioned, no?
Yeah, I have
Date,
mentioned.
date is fixed.
Yes.
So you want to
Interim order is there.
interim order and decision? It is next date of listing. Let's extend.
Item 14, your lordship.
40.
No, 14.
14.
In admission.
Uh-huh.
The interim may be extended.
Interim.
Highly authorized.
When do you want it? Take the date.
Your lordship, maybe after a month.
2/12 Tuesday. 16 mentioned for an 16. Left over 16, 2 weeks, 3 weeks to something. After 3 weeks.